today because he apparently has a hole in it.
Who? Oh. Yeah.
Holes popping up.
Right.
Should I email Miss Ward and let her know to like take the block?
Judge, do we need to do an amended?
But no, they get,
I don't-
this happens all the time. I think Miss Ward just takes off the probation hold, or whatever, but the drug court hold.
Our, but the orders was holding
Oh, okay.
because I put that language on there.
I got it. Okay.
So he's stuck and can't get to Gwinnett, released to drug court. So we'll need to release him and then put a drug court hold on him. Okay. So yeah, there'll need to be some paperwork.
Yes. Actually forgot that was after. Yeah. Almost pretty much that. Nothing down. Position 8 for this afternoon is mine, and it's really, I can start. I don't know what to do.
And Deputy Gordon, we're presiding today too. So you know, there may be people walking in with all sorts of stuff, and got Ms. Niles here and keep you on your toes. All right, do we have everyone I think we need? Let's get started. Good morning, everyone. May 5th, we have for this morning a plea and arraignment calendar. A couple cases that we will take maybe out of order depending on who's here. One of the people I needed to see just walked in. Our interpreter is here, but I don't know that Mr. Esteban is upstairs yet. Okay, so once we can get Mr. Esteban upstairs, we'll prioritize that. Is Ms. Wood going to be here, Ms. Rios?
She's walking through security.
Great. So we need to manage that one. And then we have someone from Jefferson County Prison.
Good morning. He is
There it is.
I haven't been able to talk to him yet, but his fiance called me and let me know.
Okay. Do you want to have a breakout with him? Okay. Well, let's just figure out who's here then, and then we can do that breakout so you can meet with him. Position 1 is Kerwin McCallman. You're Mr. McCallman? Okay, delayed reaction. Do you have an attorney? Oh, here we are. You were given all sorts of time to hire an attorney. Did you hire one?
Well, able to start, I think that take a loan again in my debt, ready to go. And I was not able to get a loan,
All right. Is Ms. Williams going to be here?
Is coming, Judge. She is in case management for Judge Mack.
Okay. Take a seat, Mr. McCallman. When Ms. Williams gets here, we'll have a conversation about you representing yourself, so Ms. Williams can get you discovery and go forward that way.
I do not wish to waive my rights to an attorney.
Well, you didn't appear with an attorney. This is 1, 2, 3, 4th time we've set this down, and you, for whatever reason, aren't appearing with an attorney. You don't qualify for public representation. You unfortunately don't get to box the system in by saying, I won't waive my right, but I won't hire a lawyer.
I've been trying. Obviously, I want to.
So let's wait for Ms. Williams to get here, and then we'll have a conversation about that, okay? All right. Mr. Esteban, we are waiting on. Position 3 is Bobby Ranson. I don't recognize the defense attorney. Is that a colleague? Okay.
He would be mine, but I have not had contact with him.
All right. It's a little early, and I know the entrance is a little zany this morning, but we'll see. Is Ms. Nix going to be here, or?
I believe so. Yeah, she texted me and said she's about 7 minutes out.
7 minutes. That's very precise. All right. We'll circle back to see if she arrives and if he arrives. Number 4, there was a waiver filed, and we'll do a scheduling order on Mr. Reed. Number 5, Jeffrey Keene, Ms. Rios, he's got 2 positions. You've done waivers in both, and I'm told we're going to do a bond hearing on position 5.
Yes.
Okay. Mr. Keene is one of the people downstairs, or you're not sure if he's here?
He doesn't arrive.
He's not here yet. Okay. Yeah, Cobb yesterday, we couldn't even get people on Zoom for like 2 hours. They came in, was covering someone else's calendar, and we were doing all the other things, and then at like 11, they got him into the cell. So hopefully Mr. Keene will get here soon. And Ms. Smith, are you good to go having a bond hearing on position? I think it's just position 5.
Yes.
Okay. All right. Position 7 is Tommy Brown. Mr.
Keep
Brown,
in mind if he shows up, I have not had luck with any of the numbers I have typed in.
all right. And would that be a Ms. Williams case?
It is judge and the state will request a bench warrant.
Okay. Nicavius Frazier? Ms. Rios, that yours?
Yes, he would be mine, but I have not had contact with him.
All right. Do a bench warrant there too. Makil Aklis.
This is Miss Angela Clark's client, judge. I'm covering for her today.
Right, she had a conflict. It's on just for plea and arraignment.
Yes, Judge, I think she filed a waiver. I'll double check. I know that was her intention.
Okay,
But if not, I'll make sure that same era.
all right, give me 1 second. How do you pronounce your last name? Aklis. Good morning, sir. How old are you? Who is here with you? Hello, Grandma. Thanks for being here. Are you in school? Where are you going to school? Yep, Ms. Clark did a waiver on the 29th. So, Mr. Aklis, we're just going to cover a few things. Give me 1 second, pulling up your. All right, first address. I've got you at an apartment on Washington Road. Is that correct? 17-1J. Okay, who lives there with you? Your grandma, as in the young lady sitting next to you? And? I didn't hear.
I said my auntie.
Okay, all right, just the 3 of you? All right. Want to see what your bond conditions are. You have an ankle monitor? So you're Miss Hatton?
Yeah.
Okay. Okay, so it looks like standard conditions because you're working with Miss Singleton. Last thing I want to look at is just see what. Okay. Tell me, I don't want you to talk about the facts of your case, but I need to know who Ashley Aklis is. Your mother, okay. Ms. Singleton, is McKeel supposed to not have contact with his mom as part of the bond?
That's correct, Your Honor.
Okay, all right. Do you have any brothers or sisters?
Is that, I'm sorry, It's no violent.
With mom? Okay, so you can see your mother, you're not staying with her? Okay, do your siblings stay with your mom? Are they older or younger than you? Okay, do you get to see them?
Not all the time.
Okay, you check up on them. I mean, you're the big brother. All right. So are you a sophomore or a junior? 10th grade. They don't call those things anymore. You're in 10th grade. Okay. Your school year finishes soon? What's the plan for the summer?
Get a job and, just
What kind of job?
get a job.
Any job you can get. All right. Ms. Singleton, any report on Mr. Acklese?
Not at this time, Your Honor. He is going to get permission to get a job depending on how this school year ends.
Okay.
I spoke with the school this morning. They are in testing, but he's not missing anything today.
Okay.
But there is an expectation that he should pass everything.
Good. Passing is good. Ms. Clark, who can't be here today, wanted to be sure I just conveyed to you the seriousness of the situation. You've got felony charges. I don't know how they're going to play out. You've got a great lawyer who's going to fight hard for you. And there may be a way this resolves that's not particularly problematic for you, but it's serious stuff, especially for a young man your age. And so it's important that you do your best. I know it's not easy to stay on the straight and narrow while you're out on bond. Because if you mess up, you run with the wrong guys, you get caught with something you're not supposed to have, bond goes away, no job, and you're back at, I mean, how long were you at the YDC? Well, was it 1 week, 1 month? Okay, and I'm assuming it wasn't a good experience. No, so let's avoid going back there. Do the things your grandmother tells you and what Ms. Singleton's having you to do. Do you have any questions about any part of your bond or what's going on? Okay, so what's going to happen next is that Ms. Smith, who's the prosecutor on your case, is going to get discovery. That would be police reports, body cam footage, witness statements, whatever there is, to your lawyer, Ms. Clark. She is going to want to talk to you and maybe a parent figure in your life about that, and you guys will figure out how you're going to move forward with the case. But as long as you're on this bond, you got to comply with the curfew and all the conditions that you seem to be familiar with, okay? Ms. Wood, anything on behalf of Mr. Aclese's legal team?
Thank you.
Ms. Singleton, anything I need to emphasize?
No, Your Honor.
Okay,
I believe you covered everything.
all right, pass your classes.
Oh, they already passed.
Oh, you already passed them.
He's very bright.
I'm not saying he's not, other than that he's been indicted.
I just want the court to
Right.
know that he is.
He may be our next Nobel laureate, but unfortunately he's charged with pointing a gun at his mom, not bright. And so I need to make sure he makes smart choices. People can be plenty smart here. The problem is what they end up doing. And at your age, I have a kid your age. It's just somehow this part of the brain doesn't always lead to smart choices being made, despite the horsepower that's up there. So I'm glad you passed your classes. I hope you get a fulfilling job over the summer. I will see you next when Ms. Clark has either filed some motions, if she's going to, or it's time to resolve your case. All right? Ms. Smith, anything from the state?
Yes.
Yes.
I just want to say that the side prosecutor on this case is Amanda Green. She reached out with an.
Oh, there's some DA Green on the screen here.
Was on the screen.
Oh, she cut out already? It was like 5 minutes.
I saw her on there.
Okay.
She's handling the SB 440s.
Yes, and her announcement this morning was that if she's not on the Zoom, that she will have discovery and an offer relayed to defense by May 13th.
May 13th. Okay, if you'll just relay that to Ms. Clark, that's well within whatever deadline we would have in the scheduling order. Who used to do SB 440s?
It's, Deputy Shannon tried it.
Oh, right.
She went to where I left.
And then.
Wonder how long that'll last.
And then retired.
Yeah, okay. All right, great. Well, Ms. Smith, thank you for covering for Ms. Green. Ms. Wood, thank you for covering for Ms. Clark. someday Mr. Acklese will have his lawyer and the prosecutor together and we'll see what we're going to do. Do you have any questions, Mr. Acklese?
No, sir.
All right, you're free to go.
Thank you, Your Honor.
Thank you all. All right, give me a second. Mr. Frazier? Hey, how are you? All right. You're gonna need to talk with Mr. Frazier. All right. Do you want to talk to him and then let me know if you're gonna waive? Okay, so Mr. Frazier, I gotta finish calling the calendar, so you can take a seat. Ms. Rios is gonna want to connect with you to get all your contact info, and she's gonna give you hers. And then we gotta have a quick conversation about your case before you head out, all right? Thanks. Maurice Floyd. Hey, Mr. Floyd, good morning. Ms. Wood.
I need to speak with him.
All right. Ms. Wood may be your lawyer, TBD. She needs to talk to you a little bit, and then she'll let me know if she is representing you. We've got to have a quick conversation about what we're doing. This is sort of day one with your case in my division, and we'll keep it moving along. The prosecutor on your case is going to be here shortly. She was 7 minutes out about 6 minutes ago, so she should be here soon. But you and Ms. Wood can talk once we get through the calendar. All right. 11, Darian Stewart.
Judge, you will be mindful sure that I also do not have a number.
All right. Wood, maybe bench warrant. Brianna Battle. This is who's on the screen.
Yes, Judge.
Yes.
And Judge, Ms. Battle and I actually spoke this morning. She mentioned to Ms. Wood that she was going to hire counsel, but I spoke with Ms. Wood. This was a case that I was actually already going to be sending to adult diversion. So Ms. Battle and I did speak. I will get her application over to adult diversion today. Should she not like the terms, I did let her know that if she doesn't like the terms of adult diversion and she still decides that she wants to hire counsel, that is more than okay. But it's a case that I was gonna send one way or the other, so.
Okay, so let me process all this. So Ms. Battle, I'm Judge McBurney. Good morning.
Good morning. How are you?
I'm well, yourself?
Good.
Good. So Ms. Wood, Ms. Battle doesn't qualify for public representation, or she's declining it?
She doesn't qualify right now, she makes a little bit too much money, but
Okay.
Ms. Willingham is correct.
Got it. And so Ms. Battle, I think you fall into that space that we find from time to time that rather than figure out how to spend a whole lot of money on a lawyer, if diversion ends up being something that you think makes sense for you, and it often does, you have to take care of a few things. And if you do that, the state dismisses the case. It's like it never happened, other than you had to come to court this time. Then it doesn't always make a whole lot of sense to spend money on getting a lawyer, because that lawyer is just going to say, great, give me money, and I recommend you do diversion. But you can decide on your own by reading the paperwork that Ms. Willingham will send you if you think that is reasonable, or if it's too onerous, or what. So Ms. Willingham, you have a way to communicate with Ms. Battle?
Yes, she provided me, I have her phone number and she also sent me her email address. So
Great.
I will get her application submitted today. And
Okay.
hopefully, Ms. Battle, you should have an update from me by the end of the week.
Okay. So Ms. Battle, what I'm going to do with your case is put it on what we call an inquiry calendar. And that's just so we don't lose track of it. It would be about a month out. You would need to come back to court, which could be a virtual appearance like you're doing now. But if you're accepted in a diversion, meaning they say yes, the DA's office, and you accept it, you say yes, we'll cancel that court date, because then you're doing what you need to do and we don't need to have you come to court anymore. And if, as I mentioned, if you successfully complete diversion, and I have no doubt you could do that, should you choose to do it, then the charges are just dismissed. So this today could be your one court appearance if diversion is something you are interested in doing. But if you're not, then that inquiry date about a month out will be when we talk about, well, what are next steps? You don't want to do diversion. That means either you need to get a lawyer on board because you're going to contest these allegations, or you're going to represent yourself. But we may never have to have that conversation depending on what happens with diversion. Let me confirm your contact information that we've got because you will get a notice mailed to you. So I've got an address on Pembroke Drive in Rex, Georgia. Is that correct?
No, that is not correct. That's my old address.
Okay. We need you then to update your address. How did you know that you had court today?
Because I actually got a phone call. So, and I had said that I'm like, oh, they probably send it to the email address that's on my ID. So I'm in process of going to change it on my ID as well.
Okay. Well, we need to do a change of address. Ms. Wood, would you mind helping with that?
Ms. Battle, if you'll just send me your recent address to the email we've been emailing back and forth on,
Okay.
I'll get it updated for you.
Okay, thank you so much.
So Ms. Wood will get that change of address filed, and that way the notice for your next court date will go to wherever it is you're staying now, because you don't want to miss that court date. However, we will cancel that court date if you're doing diversion instead. I think that's it. Anything else, Ms. Willingham?
Nothing further, Your Honor.
All right, Ms. Battle, where do you teach?
Skip Vision Primary School.
Okay. Well, thank you for the work you do. Ms. Willingham will let me and my staff know if you are admitted into diversion and you accept it, and we'll take it from there. Do you have any questions about the things we discussed?
No, thank you guys so much.
All right, take care.
Okay, you too.
Okay. Oh, and then we have Mr. Stevens, and that's who you need to have a breakout with. Okay, is there anyone here who didn't hear their name called? We covered everyone. Any updates about inmates being, you're gonna go get them. All right, so we're gonna take a quick break. Let me recap. We'll set up a breakout, Ms. Rios, for you and Mr. Stevens. Let me get him on the screen here. Hey, Mr. Stevens, can you hear me?
Yes, sir. Hey, how you doing?
I'm doing well. I'm Judge McBurney, and your lawyer, Ms. Rios, is gonna move into a breakout room. I'm gonna put you there as well, so you two can speak privately about your situation. You've got a new case with me that alleges fleeing or attempting to elude, reckless driving, some kind of high-speed chase. You also have a real old case in non-complex. I don't know what the charges are, but we'll probably revive that in connection with these charges. But I'm gonna let Ms. Rios talk with you, and then she'll come back out here and we'll figure out what the plan is moving forward, okay?
Yes, sir.
All right, so we'll do that. We'll bring the inmates up. Hopefully Mr. Esteban is here. And Ms. Wood, you'll talk with the few people here you needed to talk with. And then in a minute, can I stay out here? Great, okay. Then during this break, Ms. Williams, you and I, it's not gonna be a break. You and I and well, that's why I couldn't find it. Mr. McCallman are gonna talk.
Yeah.
Okay, let me set up this breakout room.
And Judge, that concludes my business till this afternoon. May I be excused?
Yes, one last thing, Rufus Suggs.
Yes.
Is he coming in this, is he a walk-in? Is
He
he,
was just on Friday and is actually moved today.
I know, but is he walking in or is he in custody? So he is someone that we had produced today?
Yes.
Okay, got it. All right, and what are we doing today?
A non-negotiated plea.
And handling a revocation? Okay, all right, and is that this morning or this afternoon?
I'm not sure what, I just know he was brought upstairs, I don't know if he's not on an official calendar, so I'm not sure which time.
Well, if we got time, let's do it this morning. All right, let me get the breakout room up.
Your Honor, I will be right back. This is the interpreter.
Yes, you are.
I need to get some water, so I'm.
Please, yes, we don't know. Senor Esteban is coming from Cobb County and that takes longer. So I don't know when he'll be here. He will be here. And when he is, we'll need you. But if you need to be elsewhere, as long as we know how to reach you.
Sure.
No,
I'll be right back.
Okay.
I don't have anything right now pending.
Great, then go get some water.
Yes, thank you.
Sure. Breakout room.
That's totally fine. Oh, perfect.
All right, they're in the breakout room. Mr. McCallman, come on up to the podium, please. Yep, right up there. All right, so tell me what your plan is, because more time isn't the plan. Well, let me take a step back. Tell me what you do for a living.
I work for an account manager for a security company.
Okay. What does that mean you do?
I manage a staff of about 34 security officers, and we're contracted out to work for a pharmaceutical company.
Okay. And do you actually do security work or you manage them?
I just manage the team.
Okay. And that's a full-time job?
Yes, sir.
What are your hours?
I kind of make my own hours, so to speak.
Okay. Is that your only job?
Yes, sir.
All right. Do you have others in your household?
My wife.
Does she work?
She does.
What does she do?
She works for the Nature Conservancy. I think she's something in finance.
Okay. And does she work full-time?
She does.
Do you have kids?
13-year-old.
Boy or girl?
Girl.
Public school or private school?
Public.
All right. Do you have any adult dependents, your parents, your wife's parents in your household that you're having to care for?
No, sir.
All right. So by all measures, you should be able to hire an attorney. I don't know, I'll let you talk in a second, but you have the right to any attorney of your choice that you can afford. But the way it doesn't work is that you shop at Neiman Marcus for lawyers, even though you should be shopping at Target for lawyers, and you say, I can't afford Neiman Marcus. You don't qualify for reasons you can understand. You work, your wife works, you have only one dependent.
Yes, sir.
You don't qualify for the public defender. It's your obligation, should you want a lawyer, to have a lawyer appear on your behalf. We are approaching the 6-month mark in you trying to line this up, either by having saved money. It sounds like you were trying to borrow money, but I worry that you are asking in the wrong places if after 6 months you haven't been able to secure representation.
Yes, sir. So initially, when this stuff all came about, and I was initially picked up, when I initially got arrested, they claimed I was a fugitive for some reason, and that initial $50,000 bond that I had to pay kind of set me back. And then when I came to Atlanta myself, because I wasn't sure what was going on, then I had to pay another bond here of $18,000, along with having a mortgage and car payments and all these things. And so it kind of, I think it's all kind of tying in, having to pay back the $50,000 bond and the $18,000 loan, along with all of our regular living expenses. And so now I'm trying to get additional loan, and they're seeing the income to debt ratio as far as all these other loans that I have out there is kind of causing a hindrance. Otherwise, as you stated, it would have been easy to get a loan.
I forgot, you have the added complication that you're not local.
Yes, sir.
Westerville is near what big city in Ohio?
New Albany, Columbus.
Columbus, okay,
Yes,
I've heard of Columbus. All right, so you are looking for a Georgia lawyer from far away,
Yeah.
okay? Have you tried to locate a local attorney, meaning one in Ohio, who,
No, I have not. I thought I needed to have someone here in Georgia, so I wasn't looking locally in Columbus at all.
you need a lawyer who can practice law in Georgia, so you probably wouldn't find exactly the lawyer for you in Ohio, but what you might do by talking to lawyers locally would be they could refer you to someone in Georgia. That's a possibility because lawyers know each other and the criminal defense bar has a national organization. I'm just throwing out ideas for you, but hearing about your debt ratio and whatnot, I understand it's not simple finances, but this case is stalled out. You are able to go about your life and the state can't move forward with the case.
Yes. I mean, yeah, I've been able to go about, but it's not, as you can imagine, with this weight on my shoulders, it's not,
I'm sure you'd like to get it resolved, but that
Certainly.
requires a lawyer unless you're representing yourself.
I would not choose to do so.
So what should I do?
Well, I am, as I mentioned before, still in the works, trying to see if perhaps with the home that we just have, if perhaps somehow we have enough equity in there that I can get, use a loan from the home equity loan. It's still in the process. I guess that takes a little time.
How many lawyers in the Atlanta area have you spoken with?
I've spoken to a lot of them, shared a lot with Mr. Remsen that I mentioned earlier, when I was here the last time, and Mr. Smith, who initially assisted me back in, 2024?
Got it. Yep. So he withdrew before your case was indicted. So he helped you early on.
He did. We had a great plan. We were making these payment plans, but unfortunately, he wasn't able to continue doing so based on all the other loans that I had to take out. Yeah.
Ms. Williams, any thoughts from the state side?
Your Honor, due to the seriousness of the charges, I would agree that Mr. McCalman would be well advised not to represent himself.
And clearly he doesn't want to. I'm not hearing him say, well, I'm not sure. I may flip a coin on that one.
I'm not sure if this is a situation in which Your Honor could appoint counsel or if that is even a potential solution.
Ms. Wood, I don't think this works at the state level. At the federal level, the federal defender can be appointed by a judge to a case when that person exceeds the income limits, but then that person is required to make some payments. But I don't think that, my recollection, I think many years ago with a colleague of yours, I said, hey, explore this. And the answer was, nah, that we don't do that. If you exceed the limits, you need to get your own lawyer.
We'll double check.
Okay.
Working on it right now.
All right. So, Mr. McCallman, ballpark, what do you earn each year?
Probably about 60-something thousand.
And your wife?
I would be guessing. I don't have an exact sum.
Do you guys file taxes separately?
She handles, since she's in finance, I let her handle all the finance stuff. So I don't really pay much attention, in that sense.
Can you reach out to her right now and find out what she makes?
Sure.
Okay.
I would just roughly say maybe somewhere about 90.
90?
Yeah.
And you're saying that with that income, you're not able to find a lawyer because you're still paying off loans for the bond you had to post?
Yes, sir. Like I said, they, for some reason, came as a fugitive, so the bond was extremely high at $50,000. And after making bond, I came to Atlanta to see what this was about, and then I had to pay another bond of $18,000. And so again, we had just gotten our home, paid mortgage and everything else. It was.
So your bond is with Second Chance.
Yes, sir.
But I'm not following, it's not, your bond is for $75,000, but that doesn't mean you have to give Second Chance $75,000. How much did you have to give them?
I think it was 18, I think it's somewhere in that 15 or 18 within that ballpark.
Okay, and have you paid them?
I'm doing some monthly.
Looks like it was more like 7,000 that you had to pay them. But I don't know how to read all their bond paperwork, but the receipt for you had to post one for each count, was 5,000 for one and
I think we might have made a down payment.
2,700 for the other. But that was also that was 2 years ago. Well, Mr. McCollum, based on your finances and how long this has been going on, what I'm going to do right now is treat you as a self-represented litigant. You are free to bring a lawyer on board whenever you want, but until you do, you represent yourself. You have been given sufficient time to line up a lawyer, and for whatever reason, you've given me some, but I don't find them sufficiently persuasive to say, well, let's give it 3 more months to see what you can do. You have had not 1 or 2 or 3, but 6 months to bring someone on board. That's enough time, rather than us holding on for another 6 months. And this case then is a whole year later, older. I'm going to ask you whether you want to be formally arraigned, where I read the charges into the record and let you know what the penalties are. Then you can enter your plea of not guilty, or if you want to waive arraignment, there's a form you can fill out. But once we handle the arraignment, that triggers the state's obligation to give you discovery in the case, which would be the evidence they have. They'd get that to you, so you could start to evaluate the strengths and the weaknesses of the state's case, figure out what you want to do in response to that, if you're going to file any motions or do something different or hire a lawyer. But that way, this case will move forward. Do you have any questions about that?
What is the difference between the two that you explained?
So if I formally arraign you, we'll get on the record, the court reporter will take everything down, and I will read into the record what you're charged with.
Yes.
And then I'll ask you if you are pleading guilty or not guilty. Assuming you plead not guilty, we'll sign some paperwork to that effect. If you waive arraignment and enter a plea of not guilty, that just means I don't read into the record what the charges are. You're still entering a plea of not guilty. And then I'll issue a scheduling order that gives the state a deadline to get you discovery, and it sets a deadline for you to file any motions if you're going to file motions in connection with that discovery.
Yes, sir. I would choose the latter.
The waiver of arraignment?
Yes, sir.
Okay. Ms. Simpson is going to show you which of those forms is the waiver form. And if you could fill that out, and you're welcome to take a seat at the table with the green mug on it. And if you need a pen, we can get you a pen. But fill all that out, and then we'll go from there.
Yes, sir.
You can sit in the middle there. Do you need a pen?
Yes, sir.
Okay, is there one on the table there?
This one.
You can borrow that one.
Thank you.
So we don't have Esteban. Oh, Esteban is here. Great. So when, and Suggs is here. Okay. Who's the last one? Oh, great. I thought that's where Esteban was. Good. King must be this afternoon or something. Or he's position what? 5. Oh, Keen. Yes. Right. We're having a bond hearing on him. Okay.
Good to see you.
Ms. Wood, you were gonna chat with, I think it was Mr. Nope, that Frazier is Rios. Who were you chatting with?
Mr. Lloyd. Position good.
Okay. And Ms. Nix is here. So are we waiving arraignment, sorting the case out?
He is going to be hiring a private attorney.
Okay,
He makes a little bit too much money for us, and he's already spoken to someone, but I don't think he's actually moved forward with retaining them. So I told him I would ask the court just for a reset for him to have time to get that together.
Mr. Floyd, how you doing?
Good, sir.
All right, so I want to avoid the conversation you just heard. How much time do you need to finalize arrangements with the lawyer?
I'll say so, this month.
Okay, so if we reset your arraignment a little more than a month out, you think by then you'd have a lawyer on board?
Yes.
Okay, we'll know that happens because the lawyer files what's called an entry of appearance. So he or she drops something in the docket and we know, hey, Mr. Floyd's lawyer is that person. You are going to get notice to be here for your rescheduled arraignment. Let me make sure we got good info for you. I got 2 different addresses for you, Hickory Lane Circle and Buffington Road.
Yes, that's the old address.
Well, I had listed 2.
What was that one?
One of them is Hickory Lane Circle and the other is Buffington Road, both in Union City. Is either one of those yours?
Yeah, and then, yes, those are old addresses.
Okay, so I need you to fill out a change of address form. Ms. Simpson is going to hold that up. Deputy Gordon's going to bring it to you. Please write legibly, whatever your current address is. How'd you know to be here today?
I spoke with a lawyer.
Okay. And that person looked it up and said you got court?
Correct.
Okay. This is our way. The court communicates with you through the mail. Your lawyer will email someone here in my chambers, but you'll always get official notices of when you need to be somewhere in court through the mail. So we need a good address. Let me check one other thing. Your bond required you to go register. Did you go register?
Yes.
All right, so you're current now.
Yes.
The allegation is you weren't current at some point, but you are now current.
That's technical. Yes.
Well, we'll decide whether it's a technicality later. That's what you need the lawyer for. All right, Ms. Nix, anything on behalf of the state in connection with Mr. Floyd's case? Okay, so you fill that out. We're gonna reset your case out a little more than a month. You have as your #1 project in connection with the case, get that lawyer on board. And then once you do, that lawyer can reach out to Ms. Nix, that's the prosecutor. You will be back here for an arraignment date, and these kinds of charges usually work out pretty quickly. Your lawyer can explain to Ms. Nix what was going on or not, and she'll let your lawyer know, well, here's what the state's willing to do. Okay? So fill that out, and get it to one of the deputies, and you're good to go.
Particularly with my last case, was that my other defendant did not appear. That be excused until this afternoon.
Let's just double check. Bobby Ranson. Going once, going twice. Okay. Yes, ma'am. See you then. So Darian Stewart never made it. Nope. Okay, bench one. But Mr. Frazier made it. And Mr. Stevens. Where's Ms. Rios? Is she talking with the client?
For the client
Okay.
in the hallway.
Mr. McCollum, if you have any questions about that form, let me know.
Yes, sir. It says defendant does not opt into discovery under, I'm not sure what that is referenced to.
So I'll tell you the two choices, and then Ms. Wood can give you her thoughts about what to do. If you opt into discovery, that means that you are telling the state, hey, I'm gonna give you the evidence that's relevant to the case that I'm required to disclose, but it triggers an obligation on the state to give you all their discovery. Most people opt in. You're not required to opt in. If you don't opt in, then the state gives you the bare minimum of discovery and you give them the bare minimum.
Indeed. Thank you.
So then, here, so that's the case number right there. So you'll just put that over there.
That's fine. Yeah.
Yes, sir. This one right here.
Can you read it?
Yes.
Okay. Just need to make sure it was legible.
Yeah.
All right, take care.
I put a dash to this.
Okay.
And then just put, is your name spelled correctly right here?
Correct.
Okay, just put it right there. Okay, so then we'll just, let's see. Are you representing yourself right now? Okay, that's fine. So for right now, just put, your name, your mailing address, your phone number.
You're good to go? Thanks.
Fill this out and then, we'll just sign your name.
Okay.
And that'll be all.
Thank you.
The other cases, the two cases in it, is, the case you just asked me.
So that he can use his flexibility in other cases. I'll talk to him about it, but there's no way you can get out of him, so per statute. Okay, we might have a public hearing, we might even have to heard it, because he was, but I still want to keep that on. I think go through the outside. Yeah. Okay.
Ms. Rios,
Yes.
can we sort out what we're doing with Mr. Stevens? Or do you need more time on that?
I'm good. I'm gonna file a waiver and he's good to go.
Okay, let me get him back on the screen, or he's probably stuck in the breakout room still. All right.
Perfect. Okay, I'll turn it in for you.
Thank you.
You're welcome.
Hey, Mr. Stevens, can you hear me?
Yes, sir.
Great. So Ms. Rios shared with me that after having had a chance to talk with you, she's going to waive arraignment on your behalf. That's just entering a plea of not guilty. That then means I'll enter a scheduling order. The state will provide all the discovery it has in your case to Ms. Rios so she can see. It's probably dash cam video, things like that. She'll review it and then she'll get with you on a Zoom call or a phone call or something to let you know what the evidence looks like. And then you and Ms. Rios can figure out how you want to move forward. Does that make sense?
Yes, sir.
Tell me, how long are you supposed to be with the Department of Corrections?
I have a date for February of 2027, but it's liable to come back farther at any time by me working. I'm at a work count.
Okay, got it. So you could be released anytime. Do you have a way to keep Ms. Rios informed of what your address will be when you get out?
Yes, sir.
Good. All right. So if you do get released, make sure you let her know where your new address is. It would be a shame for you to get out and then you miss court because we can't track you down and then there's another warrant. So just keep her posted on that front.
Yes, sir.
Why are you in custody now?
For the charges that I had caught, I violated my parole and it sent me back to prison.
Got it. You were on parole when this situation happened.
Yes, sir.
Okay. All right. I think that's it. Anything else, Ms. Rios, in connection with Mr. Stevens? All right. Mr. Stevens, any questions?
No, sir.
Okay. Well, thank you to the folks at Jefferson County for getting you on. You're good to go.
Yes, sir. Thank you very much.
Thumbs up. All right. So you'll do a waiver?
Yes, Your Honor.
Thanks.
I've also had a chance to speak with Mr. Nikidius Frazier.
Okay. We'll get to that in just a second. All right, position 8, Mr. Frazier, and
Yes, I spoke with him and I'm gonna file a waiver and he's good to go.
all right, Mr. Frazier, give me 1 second.
And do anything else after that? Then you can go back and talk about. So I'll make your announcement after she does her. You're welcome.
Mr. Frazier, you still live on Shenandoah Drive in Covington?
Yes.
Yes?
Yeah.
Things mailed to that address will get to you. Okay. One more thing. So you're supposed to stay away from Tuxedo Wine and Spirits. But if you're in Covington, you don't need to be up on Roswell Road. You've been staying away from there? Excellent. All right. Any questions about anything? You're good? All right. You know, you have good contact information from Ms. Rios? All right. So I'll enter a scheduling order. The prosecutor, Ms. Smith, is going to get discovery to Ms. Rios, and then Ms. Rios will start talking with you about what next to do with the case. Are there motions to file, or is this one that you guys should try to work out, or should it go to trial? And she'll let you know when your next court date is, but we'll also mail you something to that Shenandoah address. All right, anything else? Ms. Rios, do you need Mr. Frazier to stick around?
No, no.
Ms. Smith, anything on behalf of the state?
Nothing further, thank you.
All right, we'll see you, Mr. Frazier. Our interpreter went for a very long water break.
Well, if I could just share with the court, so, for Ms. Esteban's case, the victim is here. And so when the interpreter does return, Ms. Smith and I are going to speak with the victim, and then I'll speak with Mr. Esteban, hoping to resolve today.
We may be able to resolve it. Great. And you filed a speedy trial demand?
I did.
So that last one before April ended? No, I guess today is grand jury day, so.
I filed it, I don't know when I filed it, but it's timely.
Yeah, no, it is. It is. I'm just saying that you would, I think it's your last one because the door closed yesterday. Yesterday was the last day to file ones that run into the mess of World Cup, and would it be hard to That's what, the bench was just nervous that if there were suddenly 24 speedies filed, then how would we sort that out during the World Cup? All right, that would be great to resolve Mr. Esteban's case. Mr. McCallman, did you fill out the form?
Yes, sir.
Any other questions?
Not at this time.
All right, you and Ms. Williams should probably exchange contact information. Ms. Williams is going to need to get discovery to you. That's typically delivered electronically through a link. So here comes her business card.
Oh, I'm gonna write it down for her.
Thank you.
You're welcome.
So your address on Forest Grove Avenue in Westerville, that's correct?
Yes, sir.
So it's a mailing address. If you have an email or a phone that you would want Ms. Williams to use to send you information, you should share that with her.
Will do. Thank you.
You're welcome.
Ms. Williams, anything you want to cover in connection with this case?
No, Your Honor.
I mean, I know it's a little unorthodox right now, but perhaps this will spur progress on the representation front.
Yes, hopefully.
All right.
Raise my hand right there.
Okay, thank you.
Judge Nagler.
Yes, ma'am. All right, thank you for the assist. So, Mr. McCallman, here's where we are with your case. You are opting into discovery, you're waiving arraignment. We've got a good address for you. Ms. Williams has good contact info for you, and you have her business card, so you know how to reach her. Once my scheduling order hits the docket, which will be in the next couple days, that'll create an obligation on Ms. Williams's part to get discovery to you. You're going to continue to feel overwhelmed by all that, which hopefully will get you even more focused on lining up a lawyer to assist you with this case. That scheduling order will have a deadline for motions to be filed. That's another incentive to get a lawyer in the mix, and we'll take it from there. Anything else, Ms. Williams?
No, Your Honor.
Okay.
I believe this is my last matter on the calendar other than a bench warrant for position 7.
Well, hold on that one. Mr. McCallum, any questions?
No, sir. Not that I can think of.
All right, you are good to go. Tommy Brown, going once, going twice. Okay, that's a bench warrant, so you are all set. Thank you for being here.
Thank you, Judge. I'll be back in a second.
So Keen, we're waiting on, and
I just need to go back and talk to Queen and.
he's not here.
Oh, okay.
That's why we're waiting on.
I'll talk to the.
Oh, yeah, Suggs is here. Great. So why don't you do that? And our interpreter is back, and Senor Esteban is here.
Oh, great.
But do you want to have a conversation first with, okay, do that.
Fiscal y la plata que le dan la con dinero para explicar esto. Okay, so we speak a dialect and she hardly speaks any Spanish. Oh. That's what the daughter just said. I am the sister that, oh, Obando is my brother. Obando is my brother.
It's my mama, you know.
That's my mom, yeah.
But Maria speaks Spanish and she can speak.
Pero usted, María, ¿verdad? Okay. Usted, ¿cómo se llama? I'm Stella, she's Maria. ¿Usted habla español? She speaks Spanish. ¿Y qué dialecto habla? Campobán. ¿De dónde? Guatemala. Okay. So, yeah, it would have to be relay interpretation, if you don't mind. I mean, on the record, we really need a professional interpreter to do that, but.
But Senor Esteban speaks Spanish. So this can be informal as you're working with the alleged victim. Because I don't think that part needs to get on the record. Ms. Smith can put on the record, hey, I was able to communicate with the victim in this way, and so I think we're okay. So the young lady she can navigate. Great.
Okay.
So it's a 3-step.
No, yes. So let's go to the jury room.
Yes,
And then we'll come back out.
with the ladies. Yes. Okay, venga conmigo, come. Entiende poquito. Okay. Thank you.
Should you say for Mr. Avery, I need for the minute and to remove that language?
The revocation order said release to drug court. Yeah, we could do that. If we don't want to mess with that order, I could also, I'm trying to think what's just going to be clearest in the docket, because I could also do an order that says that it's not really a probation hold, though.
It's not, that's what I was.
And was his revocation order one where it was close enough to time served, or did he have more time he had to do?
No, he would have been picked up today.
Okay, the math worked out that he could be picked up today. But the Gwinnett hold means he can't.
Yes.
Morning.
Morning, what are you doing?
Hmm?
So what are you doing? You have donuts in the house?
Oh, well, we're about to take a break is what we're doing. Sweet. No one told me.
I know you've been, got busy fast.
Yeah, yesterday, today, nothing's happened with presiding. It's got quiet.
Yeah.
Presiding, had a wonderful.
I stepped off in the back, he's in China, placing number and a jury room with me.
Oh, okay. And Keen, is he lost again? He's not lost like Billy.
No, yeah, Carl, they haven't brought Carl over yet.
Okay. Did you ever find Billy Lowe? I need to make sure he's not lost in Virginia.
Oh, they found him. You know, they brought him back. You know, I never knew he was back there. But everybody was gone. He did the most.
Oh, I'm sure he was so pissed.
He did the most.
I'm sure he did.
Oh, I'm like, if you guys go, he called me out all type of bees and.
Oh. Yeah,
I'm like, what?
that sounds about right.
I'm like, bro, I didn't even bring you up. I didn't even know who you are.
So why did they tell us he was back there?
That's what I want to know. Y'all ain't gonna keep bringing you over. Oh, your mama, we tell my mama would do this, my mama do that. I say, what, I'll take these chances. Get down there, a whole different person.
Yeah,
Chain came over.
I spoke to him for like an hour trying to calm him down. No, like when he first got back in the jail, just to like we can get on some type of good rapport, but it took me a long time. And I'm sure the fact that I told him.
How old is he?
50s.
I'm like, where you?
But the thing is, he's probably super pissed. They go see him because he's like, y'all told me I was coming over. That's why I told you. It's like, let's bring him over so he can see you because
He gotta be on Zoom.
Huh?
He need to be on Zoom.
He can't come in person.
Well, get beat up, he come in person.
By you? Oh, that's the world.
I mean, I was like, Ms. Real, I didn't even know him. Like, I'm just trying to figure out who are you, why you up here, and I just was all type of bitch ass niggas and
Yeah, it all sounds correct to how it talks.
Hey, I like your green.
How are you? Thank you.
Good, how are you?
Good.
you know,
Check on it.
You don't hear one in your mouth?
He don't ever.
Yeah.
He do me the same way.
okay. I mean, when I be downstairs, you don't get no service. So y'all be testing it, it's still going through, but I don't find my phone until.
Then say that, cause if I'll be
I
like,
tell
I text you,
her
and then you be like, you ain't text me, and then
I
you
tell
look at your
her
phone.
that all the time.
I don't
Open the
care.
door, open the door. I be like, I don't get the message, I come back up. Man, what's up, man? Man, you know I got stuff, right?
Huh?
You know I got stuff.
Again?
No, that Saturday. Remember when they took you from me on 6 South and you went to intake? I didn't leave till about 9:30.
Why is that?
What time you got out?
7.
See? I ain't get out. I heard it was like, oh, the floor count for 5 South is done, and it's 7 South. I called the watchman like, what about me? Oh, we gotta find somebody for you. So I got something for y'all.
That's kind of wacky on that part.
And you know, I was trying to leave at 2 o'clock.
I do. They moved me from 6 hours to 5 more.
And then the intake. Who was somebody had to leave with intake on?
No, they was, had a mass or some kind of mass arrest or something. I think it's be all, especially when, people had.
Oh, yeah, they did do that weekend. It was like 44 people at one time.
You know, I used to work in politics, I just figured out who.
Mm-hmm.
All I should go around there else. Yeah, so I got that figured out.
I don't remember that case.
Okay.
Do you remember the case in Clayton? Where the lady, white lady, ran down black guy. She swore he cut her off. She followed him. And then found out that the guy was having a medical emergency. He got out the car and was trying to.
Oh, she shot him?
And she
Yeah.
shot him. You remember that? I remember.
I remember it was everywhere, yeah.
So she apparently filed an appeal and won it.
She won the appeal?
She won her appeal. And so she gets a new trial because her attorney, no, I'm sorry, not the attorney, the ADA.
Is it because she responded to AI?
Yeah.
The attorney was responding to AI?
Yeah, she got admonished.
Sanctioned the prosecutor for citing fake cases while using AI.
Yeah.
To write a brief in the case.
Like the cases didn't exist because she used AI. That's not me trusting AI. Or at least go back and look at the case number to make sure it exists and check the AI work. You can't just turn in AI work.
So the DAs did that?
Yeah.
Yeah. So the attorney got
Isn't that like?
attorney got sanctioned and she was granted a new trial.
It's real.
Huh?
Okay, you guys go. I lost kind of stuff.
What, that's our client stuff? I don't have any of my stuff in there anymore. What stuff is this? What's that?
He said stuff.
Are you sure that's ours?
Don't let her put somebody else's mess on you.
I ain't heard this. Okay, well, be careful. Yeah, it's that private thing. I was so lazy, she got one thing that she didn't get. You got some gum? I need some too. He hasn't been filling up the candy bowl, even though I don't need it, because I'm on my lifetime
Yeah, I
diet.
got to bring in a new bag.
Don't eat it, it's good, because I'm
Someone told
technically.
me to bring a bag of chips. Quick, really. I don't have no hunger headache.
They were fighting down there on, prelims.
Really?
Why?
That's it. Y vayan a, ya no les da. Thank you. Ah, no es la primera, en la segunda, perdón.
que aquí nada más es para ahí. Sí. Entonces entendieron todo, no te les mamá. Estamos esperando porque no, ya no pueden hacer nada, o sea, no, él no le puede para fianza, y como hay una orden de migración para detenerlo, entonces, dependiendo de lo que diga la fiscal, o sea, la abogada que lo acusa, recomendación para lo que diga la abogada.
Oh, so there's one.
Pero no va a salir el no.
That doesn't bode well if there's a decision to relocate more because they put a population cap. Ms. Wood, you're gonna go talk to Mr. Esteban. Does it look like things are moving towards a resolution? Great. Did I come back out too soon?
Oh, have you just came back out?
I just came back out. Yeah, I was doing work.
I'm sorry, yes, I don't think this will take that long.
Okay.
We had an extensive conversation.
No, which was good. I didn't come out till Gordon said, hey, they're done. So we're all good. All right, go talk with your client. So Ms. Rios, why are we having to redesign our lives around your Friday the 8th? What's happening on the 8th?
Well, it was just because I only have one person on that calendar and I need to prepare for those 4 or 5 trials I might have next week.
That's a lot of trials.
Yeah, well,
All right.
only can do one, but I have 5 that need to prepare.
That are potential trials.
Yes.
Okay,
And I
great.
think, yeah.
I'll learn more about that tonight or this afternoon. Did you talk with is it Suggs?
Yes, I'm ready for the pay.
Okay. I don't know that we can do that though if Deputy Gordon's back there. So, but it's ready to go. Okay. And can you give me, so he's pleading in one case and we're doing a revocation?
Yes, the case he's pleading to is the 25 SC 0078 oh no.
227.
I'm sorry, the wrong one. 25 SC 002277. Where did I get this number? It was the wrong number.
Okay.
What's the probation notification number?
The revocation case is 22 SC 181049.
But Rufus Suggs.
Ms. Simpson, what was that number one more time for the revocation?
Supplemental discovery provided today, just in time.
181049.
Okay, thank you. Oh, yeah, same case.
Ms. Smith, what's the latest on your sprawling enterprise of Harrigan, Batiste? Oh no, that's not the right one. Is this the calendar that has,
Smith.
Yeah.
oh no, it is. There's all these people, Bradford, Francis, yeah.
Yes,
What's happening with that one?
not sure, preparing for trial.
Okay. You're pressing on.
Yep.
Got it.
Are we gonna have time to do that one?
We can always make time.
Okay.
I don't know. I'll know by this afternoon when we're talking about things. What about Cotton and Genuncent?
Yes, that is a motion to sever, so it'll be 2 out of the 4.
Oh, that's 4 people.
Mhm.
Oh, look at that. Oh, you're right.
That's likely to be a trial also.
Okay. Chambers, you're saying, oh, you told me this before. Cotton and Thomas will go to trial. Right. Oh, that's Rios.
Got a lot of co-defendant cases.
Yeah. Oh, Cotton's been in for a while. The lawyer for Thomas, it says Drew Powell. That's the lawyer. I don't know Drew Powell.
Yes.
Okay. Have you interacted with Drew Powell at all? Okay. He still has final plea rights preserved. Bolton went away. What about Stephen Cook? Did we have to continue that one or that's one this is the guy who used a device to see through clothing.
Oh, I'm not sure. I think that one was resolved though.
I think so. I'll have I don't mean to bug you right now. I'll have the, like X-ray goggles. No,
Yeah, I think we did a plea on him.
you did that already? Okay, all right. Yeah, we resolved some of these already. You're right. What about Ms. Dublett? I'm remembering that's one that didn't work out.
We'll have to see what she decides on Thursday.
Okay, got it. Well, we'll talk this afternoon. I just was flipping through to see. Because you said, I have 5 cases that are gonna go to trial. I'm like, wait, what would those be? But I see, like Mr. Cotton.
What is King doing? Just a motion.
The bond hearing, I'm gonna talk to him about, I don't think he has to wrap his mind around the year to serve, so we'll have some bond hearing today.
And for the bond, are you just asking for the less? Because he has a set amount for all the applications.
Yeah, let's do the bond, let's see. How much bond does he have?
Right now it's at 10, but it's still no bond for interference.
Oh, well, yeah, we need the bond with the interference, but.
There's some of the things I know that was all. I didn't know because I saw some names there like that.
Yeah, he doesn't have a bond on the willful obstruction, interference,
Yeah.
or the hit and run.
I'm gonna send you the.
He doesn't look like
Those, I think those were DWAP or something.
Okay, let me double check.
What case, what indictment are you talking about?
The 20S. I'm calling attention to the. Was you that over DWAP?
They were not delocked, they just weren't presented to grand jury. So hit and run and willful obstruction is not, he's not indicted for that. So he doesn't have a bond for interference with government property.
Okay, that's the only one.
Yeah.
Okay. So it's fair. Leave the game stop. Let the game stop.
David,
Are you going?
no. Who's taking this pizza?
Yeah, no, I'm not interested.
Please.
Is it sports soccer?
Yeah,
Yeah,
I don't really know much of them.
You good to go?
I'm good to go. I think.
Okay, and are you gonna say can you each other, or do you want to do non-negotiated? Okay. Okay, Judge, a few things. We're ready on a non-negotiated plea for Mr. Esteban. I will just give you a preview. We'll get all this on the record when he's out here. Madam Interpreter, we have discovered that Mr. Esteban's native language is a dialect. He understands Spanish, and we've went over that in the back, and he's fine going forward with Madam Interpreter doing the Spanish interpretation, but I wanted to make sure that the court was aware.
When you say his native tongue is a dialect, meaning it's a different form of Spanish, or he speaks something other, his native language is something other than Spanish, but he happens to also be able to communicate in Spanish?
He definitely speaks Spanish.
But Your Honor, the family just informed the interpreter, his native language is Canfuban, which is the dialect from Guatemala. He does speak Spanish too, but they didn't go to school or anything, so it's.
Okay, but you've been able to communicate with Mr. Esteban speaking Spanish?
Yes, Your Honor, I did, and I asked him if he could understand me.
Mm-hmm.
or if he'd rather have someone from his native language.
Right.
And he said he understood.
Okay.
I am not allowed to lower the register in court, but in there I was using layman terms.
Okay. Got it. Well, we will try to use as many lay terms as possible as well as we work through it. Was there anything else, or you were just flagging that linguistic issue?
I just wanted to flag that for you, Judge.
Okay.
I'm sorry. It's gonna take a while.
I will move because he's interpreting.
Are you guys going to be at the table?
Yeah, that's okay.
Sure.
I think it might go smoother. You could put him by me.
And my purse there.
Yes.
Ms. Smith, are you going to, I guess it makes more sense if you're up there, because then at least you guys are talking in the same direction. Thanks.
No estén hablando en la misma dirección.
Okay, yes, we will definitely do that. Yes.
Juramento a mí y luego
All right, Ms. Rivers, good morning.
Good morning.
Ready to get on the record?
Yes, I'm ready.
Okay, this is 26 SC 000340. State versus Esteban.
el estado de Georgia en contra de Obando Esteban.
Mr. Esteban is here in court with his lawyer, Ms. Wood. And the state is represented by Ms. Smith.
Judge.
Yes.
I'm so sorry. I don't remember where we need to swear Madam Interpreter in that.
I'm about to do that. Next, we'll swear in the translator. Can you state your name for the record?
Yes, Your Honor. My name is Claudia. That's Claudia Mendez, Mendez, Porter, Porter.
Do you swear or affirm that you will translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Thank you. Good morning, Mr. Esteban.
Buenos días, señor Esteban. May I speak?
You may.
Sí, puede.
Yes, good morning.
Yes, good morning.
Mr. Esteban, we are going to rely on the interpreter in this case.
Señor Esteban, vamos a confiar en la intérprete para que ella interprete. ¿Está bien?
Sí.
Yes.
Even though you may understand what someone says in English, please wait for her to interpret it into Spanish before you answer.
Aun cuando usted entienda lo que alguien diga en inglés, espere a que ella se lo diga en español antes de dar su respuesta y conteste en español. Yes.
Mr. Esteban, it's my understanding that Spanish is not your native or original language. Is that correct?
Señor Esteban, entiendo yo que el idioma español no es su idioma original.
Sí.
Yes.
What is your native language?
¿Cuál es su idioma materno?
Anahual.
Canahuba.
Any idea how we spell that?
¿Cómo se escribe? No sé.
Ah, ¿me puede prestar?
Can I borrow a pen? The interpreter said yes. ¿Esto es A
Sí.
o Q o U?
Esa.
Okay. Okay. Q A N J O B as in boy A L was the spelling from the handwritten name given by Mr. Esteban
Okay.
and just read by the interpreter.
Mr. Esteban, are you able to understand the Spanish that the translator is speaking?
Señor Esteban, ¿usted está entendiendo el español que la intérprete está hablando?
Sí.
Yes.
Are you comfortable proceeding with the translator speaking to you in Spanish?
¿Usted se siente cómodo con lo que el español que le está hablando la intérprete?
Sí.
Yes.
If you have any questions at any time, will you please let her know?
Si usted tiene cualquier pregunta en cualquier momento, ¿le puede decir a ella?
Sí.
Yes.
Okay. Ms. Smith, when you're ready.
Mr. Esteban, please raise your right hand.
Señor Esteban, por favor, levante su mano derecha.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Causa el día de hoy en la sala será la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Thank you. You can lower your hand.
Gracias. Puede bajar su mano.
Please state your true, correct, and legal name for the court.
Por favor, diga su nombre verdadero, correcto y legal para este tribunal.
Obando Cano Esteban.
¿Cómo?
Obando Cano Esteban.
Obando Cano Esteban.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
En estos momentos se encuentra bajo los efectos o ha tomado drogas, alcohol o algún medicamento.
No.
No.
Is there any medication that you would normally take that you have not been given today?
Que usted regularmente toma y no se la ha tomado el día de hoy.
No.
No.
How old are you and how far have you gone in school?
¿Qué edad tiene y cuántos años fue a la escuela?
Tengo 24. Estuve 14 años de la escuela.
I'm 24 and I went to school 14 years.
As English is not your native language, do you understand that you have been provided an interpreter to explain what is going on?
Como inglés no es su idioma principal, le han proporcionado una intérprete de español para que pueda entender. Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Entiende que usted puede declararse culpable o no culpable ante los cargos que hay en su contra. Y si se declara no culpable, se iría a un juicio ante los miembros de un jurado para que decidan su caso. ¿Entiende?
Padre.
Yes, guilty.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
¿Ha usted tenido suficiente tiempo para hablar con su abogada sobre los hechos y las circunstancias de su caso antes de pasar al tribunal aquí? Y sobre lo que tiene que ver con el juicio. ¿Ha tenido suficiente tiempo?
Ahorita, sí.
Right now, yes.
Do you need more time to discuss your case with your attorney?
¿Necesita más tiempo para hablar de su caso con su abogada?
Do you have any more questions for me?
¿Tiene más preguntas que hacerme a mí?
Sí.
Yes.
So, Mr. Esteban, we can pause and you can speak with Ms. Wood as long as you need. Do you have more things you want to discuss with Ms. Wood?
¿Quiere hablar de más cosas con su abogada, la señorita Wood?
Or are you ready to move forward?
¿Está listo para seguir?
Estoy listo para seguir.
I'm ready to proceed.
Okay. If you have any questions at any time, just let me know and you can speak with Ms. Wood.
Si tiene cualquier pregunta en cualquier momento, déjeme saber y puede hablar con su abogada, la señorita Wood.
Sí.
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Fecha con el tiempo que ha hablado con su cliente antes de proseguir.
I am.
Sí, lo estoy.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this
Tenga que
plea?
leer formalmente la acusación formal en su caso.
We do.
Sí, lo hace.
Mr. Esteban, do you remember being arrested on these charges?
¿Recuerda cuando lo arrestaron por estos cargos?
Sí.
Yes.
Ms. Wood, the state is unaware of any outstanding warrants related to these charges. Are you or your client aware of any outstanding warrants?
¿Sabe si hay alguna orden respecto a este u otros cargos en contra del señor?
We are not.
No, no sabemos.
Mr. Esteban, do you understand that this is a non-negotiated or a blind plea?
Esta es una negociación
And-
de que no fue negociada y que lo está haciendo a ciegas al presentar su declaración de culpabilidad.
Sí.
And that the state will recommend a sentence to the court?
Que la fiscalía va a ser la que recomienda la sentencia al juez.
Sí.
Yes.
Do you understand that the court can impose any sentence authorized by law?
Cualquier sentencia autorizada por la ley.
Including a higher sentence than that recommended by the state?
Una sentencia mayor a la que fue recomendada por la fiscal.
No.
Up to the maximum, sorry. The ending of that is up to the maximum sentence on each charge or on this charge.
La máxima sentencia que se le puede dictar o imponer por cada cargo. ¿Entiende?
Sí.
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit
No puede quebrantar ninguna de las leyes constitucionales o del gobierno o de sus unidades. ¿Entiende?
Sí.
or any special conditions of probation without being subject to revocation for the balance of the sentence.
Sin que le revoquen o se le quiten el resto de la sentencia y lo puedan poner a cumplir esa sentencia si quebrantan las condiciones. ¿Entiende?
Sí.
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Entiende que esta declaración de culpabilidad va a aparecer permanentemente en sus antecedentes penales. ¿Entiende?
Sí.
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Acusan de un delito en un futuro, esta declaración que está haciendo ahora la pudieran utilizar para incrementar el tiempo de la sentencia de otro delito que si cometiera otro delito pudieran utilizarlo en su contra, ¿entiende?
No.
No.
Would you like me to repeat it?
¿Quiere que lo repita?
Sí.
Yes.
Do you understand that if you are charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Esto pudiera afectar el tiempo que le den de sentencia en ese caso y eso incluye cualquier caso federal también.
So basically,
Básicamente lo que quieren decir con esto,
if for some reason he
si
was
por algún momento,
allowed to stay in the United States,
si por algún motivo lo dejan quedarse en los Estados Unidos
and he got arrested
y
again,
lo arrestaran de nuevo,
the state of Georgia would be able to bring up
el
this case.
estado de Georgia pueden ver este caso.
Ujú.
Ujú.
Do you understand that?
¿Entiende eso?
Sí.
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Salir por buen comportamiento antes de la cárcel, esta declaración de culpabilidad la podrían ver al declararse culpable el día de hoy.
Sí.
Y que si quebrantan las leyes lo podrían volver a arrestar.
Sí.
Yes, yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status?
Culpabilidad pudiera afectar su situación migratoria.
Sí.
And
Yes.
do you also understand that it will result in deportation, just like a conviction at a trial would?
Como una condena en un juicio.
And that this is true regardless of any advice by your attorney or anyone else?
Independientemente de lo que le haya dicho su abogada o cualquier otra persona que tiene efectos con inmigración, su declaración. ¿Entiende?
Sí.
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Al declararse culpable. ¿Entiende?
Sí.
Yes.
For example, do you understand that this guilty plea conviction may affect your right to vote, the right to hold public office,
El que vote, el que tenga un puesto público,
the right to serve on a jury,
el que pudiera
the right to
ser
obtain a passport,
que pueda obtener un pasaporte,
or the ability to obtain
o la
employment?
posibilidad de poder obtener un empleo.
Sí.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive,
No puedo
possess,
usar, poseer, recibir
transport, or own a firearm?
o tener arma de fuego?
And that if you did, you could be charged with another felony
Lo
offense.
hiciera y tuviera un arma, le pueden poner un cargo de un delito grave por eso. ¿Entiende?
Sí.
Yes.
Do you understand that you waive any and all defenses,
Está renunciando a cualquier defensa al declararse culpable,
including any mental health defenses,
incluyendo el de salud mental,
by entering
Yes.
this guilty plea?
al declararse culpable?
Sí.
Yes.
Do you understand that by pleading guilty, you are giving up the following rights?
Dando a los
The right to a trial by jury,
el derecho a tener un juicio ante un jurado
the right to remain silent and not incriminate yourself,
para no incriminarse,
the right to see and hear the witnesses called to testify against you,
escuchar testigos que vengan a declarar en su contra y poderse cariar con ellos,
the right to assistance of counsel, either hired by you or court appointed if you cannot afford an attorney.
o que le nombren a uno si usted no tiene los medios para contratar a uno propio.
The right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges.
Hasta que la fiscalía compruebe más allá de una duda a la cual se le pueda dar razón que usted es culpable de los cargos.
The right to
Yes.
the right to testify on your own behalf or remain silent,
El que usted pueda declarar de su parte o mantenerse en silencio en un juicio,
the right to present other evidence of your own,
presentar cualquier otro beneficio que pudiera servirle de su parte,
and the right to appeal if convicted of these charges after a trial.
Ante estos cargos como lo podría hacer luego de un juicio. ¿Entiende?
Sí.
Yes.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Al decir que su cliente está entendiendo todos sus derechos constitucionales y aún así se declara culpable.
I am.
Sí, estoy satisfecho.
Mr. Esteban, has anyone forced, threatened, or promised you anything to get you to enter into this guilty
¿Le ha
plea?
hecho alguna promesa falsa para que usted se declare culpable aquí el día de hoy? No.
As to indictment number 26 SC 000340,
340.
how do you plead to count one aggravated assault?
Es por agresión con agravantes, o sea, lesiones. ¿Cómo se declara?
Sí.
Yes. Aquí es donde dice culpable.
Sí.
Yes. Tiene que decir la palabra.
¿Cómo se dice guilty? What's the word? Okay.
Yes, guilty.
Yes, guilty.
Okay.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against
Libre y
you?
voluntariamente, habiendo conocido y sabido cuáles son los cargos que hay en su contra.
Sí.
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea?
Entiende que usted directamente no puede apelar a su declaración de culpabilidad directamente. ¿Entiende?
But
Yes.
But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Pero si usted considera que se cometió un error en su declaración de lo que se efectuó aquí el día de hoy, puede ir a solicitar una apelación a cualquiera de los tribunales que son pertinentes para esto. ¿Entiende?
Sí.
Yes.
Do you understand that that process must be completed 30 days from today?
entiende que ese proceso se puede efectuar, le dan de plazo 30 días a partir de la fecha de hoy para poder hacer eso. ¿Entiende?
Sí.
Yes.
Do you understand that you have only 4 years from today for a felony charge?
Le dan 4 años a partir de la fecha de hoy
To file a habeas corpus petition challenging the voluntariness of this guilty plea.
para disputar, o sea, pelear el que la declaración del día de hoy la hizo de voluntad propia y puede solicitar un amparo que le dan 4 años. Se llama habeas corpus. ¿Entiende?
Sí.
Yes.
Okay, thank you, Mr. Esteban.
Está bien, gracias, señores.
Sí.
Your Honor, if this case were to proceed to trial, the state would show that on October 15th, 2025, officers of the Atlanta Police Department responded to
Respondieron a
a fight in progress at 532 Cleveland Avenue Southwest,
Southwest,
Atlanta, Georgia,
Atlanta, Georgia,
also in Fulton County.
también en Condado Fulton.
When the officers got there,
Entonces llegaron ahí.
they spoke to Neglil Cano. First name is spelled Neglin. Last name is Cano. Cano told the officers that their grandmother, Maria Esteban, was attacked by the defendant in this case, Mr. Esteban.
Esteban.
Ms. Cano took the officers to Miss Maria Esteban's room.
Al oficial a la habitación de María,
Where the officers observed a significant amount of blood on the floor.
Mucha sangre, bastante sangre en el piso.
And also observed the victim sitting on the bed with a towel held to her head.
Con una toalla que tenía puesta en la cabeza.
The officers began to apply pressure to the wound.
Empezaron a poner presión en la herida.
And also called EMS to the scene to render aid.
Los primeros auxilios para que vinieran a ayudarla, a los paramédicos, a ayudarla ahí en el lugar de los hechos.
While the officers were applying pressure to the wound, they were able to observe a large, deep laceration
Una gran laceración
in the victim's skull
en
on the left side of her head.
la parte izquierda de la cabeza de él.
A second laceration was noted closer to the front of her head.
Estaba enfrente de la cabeza.
Both lacerations were bleeding and appeared to be consistent with being struck with the claw side of a hammer.
Con el golpe de parte del martillo.
The left side of Maria Esteban's head was covered in dried blood, as well as blood on her shirt and neck.
También en la camisa de sangre está mancha.
Miss Maria Esteban was transported to Grady Hospital, where she received care for her injuries.
Recibió cuidados por sus heridas.
The officers then spoke with the reporting party, Lucia Esteban. First name is spelled Lucelia. Last name is Esteban.
BAN, Lucía Esteban, quien reportó esto a la policía.
Miss Lucia Esteban stated that her mother, Maria Esteban, called her about an incident that was occurring with her son, the defendant in this case.
Con su caso, en este caso.
Lucia stated that the suspect in this case, who was identified as the defendant, assaulted her mom, but it was not the first time.
Agredió a la mamá y que no era la primera vez.
Lucia was able to provide the officers with a picture of the suspect, who was identified as the defendant.
Sospechoso, identificado como el acusado.
Lucia stated that her mom and brother got into an argument about money
Sobre dinero,
that turned into a physical altercation.
llegó a ser un altercado físico.
At this time, the defendant was not at the home.
I'm sorry, the interpreter couldn't hear.
The defendant was not at the home.
Thank you. El acusado en ese momento no estaba en la casa.
However, the day after, on October 16th,
Al día
2025,
16 de octubre del 2025,
officers of the Atlanta Police Department
la Prefectura de Atlanta
were called to 501 Connell Ave, that's Connell, in Atlanta, Georgia, also Fulton County, where the defendant, Mr. Esteban, was located and arrested for the charges we have before us.
por estos cargos.
Those are the facts and circumstances of the case.
Con este caso.
Regarding the recommendation from the state is asking for a sentence of 5 years to serve 1 with the balance probated.
El resto bajo libertad condicional.
We do acknowledge that there is an ICE hold.
Sabemos que hay una orden de inmigración y aduanas para aprenderlo.
However, if that hold is resolved,
y se resuelve esa aprehensión y lo dejan salir,
the state is asking for the defendant to have no violent contact with the victim,
contacto violento con la víctima,
to complete an anger management course,
un curso para controlar su ira,
and to participate in a drug and alcohol evaluation with treatment if necessary.
el tratamiento que ellos consideren necesario.
The state did get an opportunity to talk to the victim, Mr. Esteban's mom in this
La
case.
víctima, la mamá del señor Esteban,
She did inform the state that the argument was not about money, but more about
la discusión no era tanto por dinero, sino
the defendant coming in at a late time that she disagreed with.
tarde a la casa.
On the night of the incident, when the defendant got to the home at a later time,
La noche en que él llegó a la casa,
the victim, in this case, his mom, took a belt with the intention to
ella
whoop him.
tomó un cinturón con la intención de darle con el cinto.
Once Ms. Esteban got the belt,
Una vez
the
que
defendant, in this case, grabbed the hammer.
la señora Esteban, el señor Esteban agarró el martillo.
Ms. Esteban stated that people started to intervene,
La señora Esteban trató de intervenir
and that is when the defendant threw the hammer on accident.
él tiró por accidente, aventó el martillo.
The mom stated that the defendant has a problem with drinking,
Tiene problemas con la bebida.
and when he drinks, he does not, when he drinks, he sometimes fight and get into these arguments with herself and family members.
Se vuelve problemático para la familia.
The victim in this case
La víctima
acknowledged that she disagreed with the state's original offer,
no estuvo de acuerdo con el ofrecimiento original que quería dar para la sentencia de la fiscalía.
and is more in support of the defendant being deported and spending more time in jail or prison.
En lugar de que pase más tiempo preso.
The state does recognize
La fiscalía reconoce
that the incident report mentions 2 lacerations to the victim's head, one being a deep laceration.
y una era profunda laceración, o sea, las cortadas que le causó el martillo.
However, based on the facts and circumstances of the case, the victim's wishes, and the defendant's ICE hold, the state is requesting a 5-serve-1 offer or sentence in this case.
Para que pase uno como sentencia en el caso.
And that is all from the state, Your
Y
Honor.
eso es todo lo que pide la fiscalía.
Was the offer higher before you had a chance to speak with Maria Esteban?
It was.
Thank you.
Gracias.
Ms. Harvey from pretrial, do you have any criminal history information on Mr. Esteban?
Antecedentes penales. ¿Tiene antecedentes el señor Esteban?
3 cycles out of Georgia and 1 cycle with ICE.
En Georgia, yo no por
You came in only at the very end. How many cycles in Georgia?
3.
3. Okay.
Does not appear to have any felony convictions.
no parece tener cosas penas.
There is a case out of Fulton County for battery family violence and simple battery family violence that appears to be in bench warrant status.
Que
Do you have a case number for that?
En el número de casos.
Yes, Your Honor.
Sí, su señor.
Case number 25 CR 002 349 B as in boy.
Thank you.
There also appears to be an ICE hold and nothing.
All right. Thank you so much.
Por invitación de aduana. Gracias. Muchas gracias.
There you are.
What was that case number?
25 CR 002349 B Bravo. It is your client, last name Cano rather than Esteban, but it's Ovando. It's assigned to Judge Porter. It is in bench warrant status.
Orden de arresto.
Interestingly, the accusation was entered 1 year ago today.
Fue hace exactamente un año atrás.
Thank you, Judge.
Gracias.
You're welcome. And it alleges that Mr. Esteban caused visible bodily harm to Lucy Cano.
This goes a Lucy. Lucy.
Check the other. Yeah, so Lucy, I don't know who that is to him. It's not mom.
No es la mamá. ¿Es su hermana? Yes.
It's a sister, Judge.
Sister, the young lady in pink.
La joven que está aquí en rosa. Dicen que hace un año hay un caso.
Are you Lucy?
Usted es Lucy. I'm sister.
Okay, so they're two sisters at least.
Hay dos hermanas. Yes.
Okay, got it. All right. Ms. Wood.
Thank you, Judge. Mr. Esteban is 24 years old.
Tiene 24 años de edad.
He's originally from
Es
Guatemala.
originario.
He has been here in the metro area for 5 years.
Área metropolitana por 5 años.
I have been speaking with Mr. Esteban
Con el señor Esteban.
with an interpreter from my office,
Intérprete de mi oficina.
who had also been
Que
speaking to the
también
family as well.
con la familia.
And it was our understanding that alcohol was heavily involved.
El alcohol es algo que está muy involucrado en esto.
He actually, some years prior,
7 años antes,
fell out of a
se
tree,
cayó de un árbol,
suffered a head injury,
una lesión en la cabeza.
and it sounds like he may have turned to self-medicating with
Él
alcohol.
se empezó a medicar solo con alcohol.
On the day in question,
En el día en cuestión,
like Ms. Smith said,
como dijo la señorita Smith,
he came home late. There was an argument between the family.
una discusión con la familia.
All parties agree that he
Están de acuerdo.
accidentally
Él por
hit the mom with the
accidente
hammer.
le pegó a la mamá con el martillo.
It wasn't that he pulled out a hammer and started banging her in the head.
Sacara un martillo y le empezara a pegar en la cabeza.
Nonetheless, she was injured.
Sin embargo, ella resultó lesionada.
And so he understands that that's how this case came about.
Que es como se empezó este caso.
We are asking the
Nosotros
court
estamos pidiéndole al juez
to perhaps do a suspended
que
sentence.
le dé una sentencia suspendida.
He's been in custody 201 days.
Ya ha estado preso 201 días.
So my request would either be
Sería
1 year to serve,
Un año
reduced to
para-
time served.
va a estar preso, pero que le quitaran el tiempo que ya pasó preso, como sentencia que le dejaran ya el tiempo que pasó preso.
Or if the court is inclined to go with the state's
Si el juez
recommendation.
quiere seguir la recomendación que dio la fiscalía,
I would ask that the remainder be
Pediría
suspended.
que el resto fuera suspendido.
I do expect him to be
Yo
deported,
espero que lo van a deportar.
and he and the family are
Y
aware
él
of
y
that
la
as well.
familia están conscientes, saben esto.
And that's all I have.
Y
I'm
eso
not
es todo
sure.
lo que tengo. No, no sé.
I'm not sure if the family wanted to speak to the
No
court.
estoy segura si la familia quiere hablar con el juez.
Why suspend rather than probate?
En lugar de poner bajo.
Which would mean if he's not removed, we can't get him some alcohol treatment.
Si no lo ponen bajo libertad
I think I was
no
just-
podemos tener ayuda para él sobre drogas y alcohol.
Fair question, Judge.
Es,
I was thinking about it in terms of,
eh,
and maybe I don't understand it well enough, but I was
Pero no-
thinking about probation not having to open a case for someone who's not here.
Who's just being removed.
para
Yes.
alguien que
Okay.
no vaya a estar aquí,
Got it.
que lo van a-
Mr. Esteban, is there anything you want to share?
¿Hay algo que usted quiera decir?
Por ahorita no.
Not for now.
Solo quiero saber cuánto tiempo de estarse aquí y tener la libertad.
I just want to know for how long I have to remain here until I let go.
Okay. Do you have any kids?
¿Tiene hijos?
No.
No.
How many brothers and sisters?
¿Cuántos hermanos y hermanas tiene?
Tengo 3 hermanos y otro hermano. 3 hermanas y 2 hombres.
I have 3 brothers y 2 mujeres, 2 hermanas.
3 hermanas y
Oh.
2 hombres.
Oh, 3 hermanas y 2 hombres.
Mm.
3 sisters and 2 brothers.
Are they all here in Atlanta with you?
¿Todos están aquí en Atlanta con usted?
Sí.
Yes.
If you go back to Guatemala, do you have family you can stay with?
Usted regresa a Guatemala, ¿tiene familia con quien quedarse allá?
Sí.
Yes.
Okay. Any questions?
¿Alguna pregunta?
Other than how long do you have to stay in jail?
Aparte de cuánto tiempo va a permanecer en la cárcel. Yes.
Solo saber cuánto tiempo de estarme en la cárcel y tener mi libertad o derecho de la salida, de una salida.
Just how much more time I'm gonna remain in jail and when will I be able to get out?
Okay, we'll talk about that.
Bueno, vamos a hablar de eso.
So, Mr. Esteban, I find that there is sufficient evidence to support your plea.
Pruebas que apoyan su declaración.
And that your plea is what we call knowing and voluntary.
Y que su declaración la hace con conocimientos de lo que pasó y que lo hace de voluntad propia.
Meaning that you've understood what we talked about.
Es decir, que entiende de lo que hablamos.
And if you didn't, you ask Ms. Wood questions.
Que si no entendía algo, le podía hacer preguntas a su abogada, la señorita Woods.
And also meaning that no one is forcing you to enter this plea.
Forzando para que usted se declare así el día de hoy.
Do you agree with that?
¿Está de acuerdo con esto?
Sí.
Yes.
Ms. Wood, can someone in my office sign the indictment for you?
¿Puede firmar la acusación formal por usted?
Yes.
Ms. Smith?
Señorita Smith.
Yes, Judge.
Please, señor.
And Mr. Esteban, can we sign your name on the indictment
Firmar su nombre de su
indicating your guilty plea?
indicando que usted se está declarando culpable?
Sí.
Yes.
Thank you.
Gracias.
Do you understand, Mr. Esteban, that this guilty plea will very likely result in your removal from the United States?
Que lo expulsen, lo remuevan de los Estados Unidos. ¿Entiende? Yes.
Understanding that, do you still want to go forward with your guilty plea?
¿Aún así quiere usted seguir con su declaración de culpabilidad?
Sí, sí.
Sí. Yes.
Okay. Mr. Esteban, I am going to sentence you in this case
Sentenciar en este caso
to 5 years,
5 años,
to serve 10 months
10 meses,
with the balance on probation.
Preso con el resto bajo libertad condicional.
You will get credit for the time you served,
El tiempo, le van a dar crédito por el tiempo que ya pasó preso.
which is almost 7 months.
Casi 7 meses.
If you are released to probation
Y lo dejan
before you are removed from the U.S.,
antes de que lo remuevan de los Estados Unidos.
you have 3 special conditions.
Tiene 3 condiciones especiales que debe cumplir.
First,
La primera,
no violent contact
no puede tener contacto violento
with your mother
con su mamá, con su madre
or your sisters.
o sus hermanas.
Number 2,
Número 2,
you will take an anger management course,
curso para
and you need
dar su ira.
to take that within the first 6 months of your probation.
Debe tomarlo en los primeros 6 meses de que permanezca bajo libertad condicional.
And number 3,
La número 3,
you will submit to a drug and alcohol abuse evaluation,
hacerse a una evaluación sobre alcoholismo y drogadicción.
and if the person you talk with recommends any treatment,
La persona que hace la evaluación considera
that treatment is part of your probation.
ese tratamiento es parte de las condiciones que debe cumplir.
But if you are removed from the U.S.,
Mueven, lo expulsan de los Estados Unidos.
you don't have to do any of those things.
No tiene que hacer ninguna de esas cosas que no está aquí.
Sí.
Yes.
Any questions about that?
¿Alguna pregunta al respecto de esto?
No.
No.
If you are released from jail,
Salir de la cárcel.
would you be living again on Cleveland Avenue?
¿Usted sería vivir de nuevo a Cleveland Avenue?
No lo sé.
I don't know.
Where do you think home would be? If you got out of jail tomorrow, where would you go to stay?
Si usted saliera de la cárcel mañana, ¿a dónde se iría a vivir?
Con un hermano.
¿Hermano?
Sí, con un otro hermano.
With a brother, another brother of mine.
Okay, and where does he stay?
¿Y dónde él se queda? ¿Dónde vive?
Vive aquí de Hayview.
Hey,
Hayview.
Hayview.
Hapeville?
He lives in Hayville or
Yeah.
Hayview.
Helby.
Hapeville, Hapeville.
Bill, Hapedille. Yes.
Okay. Fulton County.
Condado de Fulton.
If you are released from jail, you need to report to probation within 2 days.
En 2 días a más tardar tiene que reportarse con los de la libertad condicional. Tiene que poner.
I don't think that will happen.
Yo no creo que eso vaya a pasar.
I think ICE is going to come get you.
Yo creo que hay, o sea, inmigración y aduanas va a venir por usted
And they will remove you,
y lo van a remover, lo van a expulsar.
but I don't control that.
Pero yo no controlo eso.
So it may be that you get released.
Puede ser que lo dejen salir,
You need to make sure you report to probation.
pero si es así, tiene que irse a reportar con los de la libertad condicional. ¿Entiendes? Yes.
All right. Ms. Wood, anything else?
No, Your Honor.
Ms. Smith? Ms. Simpson? You're good? All right. Any questions, Senor Esteban?
Señor Esteban?
Por ahorita no.
Not for now.
All right. Good luck out there.
Gracias. Digo, buena suerte. Yes.
Will you go with me?
Yes.
Briefly.
Yes.
I'm right there.
Ms. Rios, are you ready on Mr. Suggs? Pardon me? Sure. So Ms. Rios, this is a plea to the 25 SC case that was originally non-complex.
Yes.
And then we have a revocation. Does he have any other moving parts?
I don't, not that I'm aware of. I think probation said that he might have a hold, but she saw it's closed, the pretrial had it open or something.
Okay, I don't see any warrants here, but those holds often sneak up on us. Okay, but it would be a hold from some other jurisdiction. It's nothing we could deal with. Okay.
My pleasure.
Boy, that was a long one. Nice work. Appreciate your help. Yes, ma'am. There you go. Hello, Mr. Suggs.
Morning, Jan.
Good morning. How are you?
I'm great. How are you?
I'm hanging in there. Ms. Smith, are you ready?
Yes.
Okay. Let's go on the record and, Ms. Harvey, this was not on one of our calendars. This is something that we brought in just to help one of the lawyers manage her schedule. Do you need the case number or have you already had a chance to look Mr. Suggs up?
I already have it, Your Honor. Ms.
Fantastic.
Mills provided me with the information.
Thank you.
Thank you.
All right. Well, then let's get on the record. This is 25 SC 002277, State versus Suggs. Mr. Suggs is here with his lawyer, Ms. Rios. We have Ms. Smith for the state. And Mr. Suggs, it is my understanding that you are prepared to enter a plea in the case that I just mentioned, and then we're also going to deal with a probation revocation. Is that your understanding?
Yes, sir.
Okay. Ms. Smith will put you under oath, ask you questions about your case and about your rights. You need to answer her questions truthfully and completely. You also need to let me or Ms. Rios know if you've got any questions so we can answer those. Will you do that?
Yes, sir.
All right, Ms. Smith.
Mr. Suggs, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Rufus Suggs III.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
30. 30. I've been to 12th grade, but I got my GED.
You're 30, like 30.
Yes, sir.
Okay, and you have your GED.
Yes, sir.
Thank you.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Suggs, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you also understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Suggs, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 002277, how do you plead to count 1, possession, distribution, and sale of marijuana, count 2, possession of firearm during commission of certain felonies, and count 3, possession of firearm by convicted felon?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Suggs. Your Honor, if this case were to proceed to trial, the state would show that on April 6, 2024, officers of the East Point Police Department, they were working in an undercover capacity while monitoring a Texaco service station located at 3155 Camp Creek Parkway, that's in Fulton County. The officers in this case observed a black male seated in a black Chevy Impala parked outside the main entrance of that Texaco. While observing this male, they were able to see that several individuals approached him, and the defendant, who was identified as the male seated in that Chevy Impala, conducted several hand-to-hand transactions where he exchanged a clear plastic bag containing what appeared to be raw marijuana for U.S. currency. At this time, the officers conducted a takedown of the defendant where they placed him in handcuffs and placed him under arrest for the charges we have in front of us. While searching the car, they did find a Smith & Wesson firearm where they then added the charge of possession of firearm during the commission of a felony. And then once they checked his history, they added the possession of a firearm by a convicted felon based on the previous criminal charges that he has. Those are the facts and circumstances of the case. Regarding the plea, regarding the recommendation from the state regarding this case, give me 1 second. The state is recommending a sentence of 8 years to serve 3 with the balance probated. For counts 1 and count 3, we're recommending 3 years to serve for both of those counts to run concurrent. And then for count 2, 5 years to run consecutive. Regarding the special conditions of probation, the state is asking for the defendant to have no drugs without a valid prescription, to pay a fine to the court of $500, to stay away from the incident location, and to have no guns or replicas. What went into the state's recommendation is, in this case, is kind of an overview of the defendant's criminal history at the time that the defendant committed this crime back in April of 2024. He was currently on probation for financial transaction, card theft, and fraud that he pled to in February of 2024. The defendant was also on probation of possession by a convicted felon out of North Carolina. Because he was on probation for 2 cases and committed this new offense, a similar offense, the state does believe that the defendant continuously is a risk to reoffend. Also, the defendant does have 3 previous convictions for possession of a firearm by a convicted felon out of North Carolina. This raised some concerns with the state that the defendant does not know how to stay away from guns. And because now, with this new charge or new case here, he does have another firearm. It does raise concerns for the state. Because of that, we are recommending an 8 serve 3 with the balance probated in this case. And that's all from the state, Your Honor.
Thank you. Ms. Simpson, how much time remains on the 22 SC probated case?
Yes, 2 years, 9 months, 14 days.
A little less than 3 years. Okay. All right. And Ms. Harvey, I have seen the state's repeat offender notice that caused this case to bounce from non-complex to my docket, which shows 6 felony convictions. How many total cycles do you have, and do you have more than 6 felony convictions?
I do show 6 felony convictions, Your Honor. I show 10 cycles out of Georgia and 13 cycles out of North Carolina and 1 cycle out of Florida.
Got it. Okay. Thank you so much.
Yes, Your Honor.
And we are good until 1. If you want to hit your lunch break, we're going to be reconvening at 1 o'clock for more business.
Okay, see you at 1. Thank you.
Thanks. All right. Ms. Rios.
Yes, Your Honor. Mr. Suggs is 3 years old.
prior to being in custody, he was working at Tip Top.
Tip Top Poultry.
Yes.
All right.
Live hang, and had been working there since 2023, and he had a lead position, and he believes he would be able to get that job back once he's released. He has 3 children, ages 11 and 11 and 2 7-year-olds. And he did obtain his GED. I've been talking with his fiance, and they have a lot of concerns about the condition of the 11-year-old, and they want him to be out so he can get custody of her. I think the fiance went to go visit her, and the way she looked disheveled. She was concerned if she was eating enough food, but he's not going to be able to get her because she can't get her on her own. He needs to be out for them to get her, and they plan to move her to Georgia, hopefully enroll her in school. My understanding is that she has other siblings with her mom and may just not be getting enough attention. And he was an active father before he got in custody and wants to be able to get custody and have his child in his home with his fiance, who is on the Zoom. She's been very proactive.
Is this our iPhone?
I believe so.
Okay.
It should be Sierra.
It just says iPhone, but there's been an iPhone on all morning.
Yes, she's been very proactive, reaching out to me about what's going on in this case because she needs him home so he can go back to work as well. When it comes to the facts of the case, the firearm was underneath the seat and he was not visible, and was able, and his girlfriend did come to, or fiance come and retrieve the gun because it's registered in her name. It's her gun. I do understand his history, but given that, and I believe other than picking up this case, he was reporting on probation. There wasn't any like technical hiccups from my understanding. So I'm asking for him to have a probated sentence. Count 1, I'm asking for 3 years probation. Count 2, 5 years consecutive probation, and then count 3, 3 years probation to run concurrent with count 1 and a behavioral incentive date.
All right. Ms. Smith, the fine is just a condition you came up with? Because I don't think we have these counts all the time and there's not always a fine.
Yes, it's
Okay.
because of the repeated offenses.
Okay, I wasn't criticizing it. I didn't remember there being a fine linked to any of these, but I got it. Ms. Simpson, do your records show Mr. Suggs doing okay on probation until this arrest? Although I guess that's saying he did okay on probation for 2 months, because this was an April 24 arrest and it sounds like he pled in February of 24. So I guess we could be impressed that he hadn't had any troubles, but it was 2 months.
Well, prior to that, we got his case from North Carolina, so.
Okay.
In addition to 22 SC case, he was on parole for a North Carolina case here as well. That expired in July of last year.
Okay.
Which I was gonna ask, and reach out if she saw, a warrant from them. It was expired in our side.
Okay.
I just didn't know if I need to close it.
I said she could go to lunch, so I didn't know that. She's
That's
gone.
fine. I'll ask her this.
Okay. Mr. Suggs, there may be a hold for you out of North Carolina. I don't know. It doesn't show up on our system, but those don't always show up. So that'll be something to navigate if it's there at the appropriate time. Is there anything you want to add?
Yes, sir. I just want to really apologize to my fiance and my family because.
And what's her last name?
Scott.
Miss Scott. Okay. Miss Scott, are you able to, you can just wave your hand if you're able to hear us. She's there. Hey, Miss Scott. Okay, she can hear you. How long have you two been fiancés?
It's 2019.
That's kind of a long fiancé-ship.
And I've been working on rehabilitation.
Yeah, you've been having some issues that make that complicated.
So
Having some issues and I'm sticking around.
Yeah, well, clearly here you are. You've been on the call all day.
So I really want to apologize because I've been putting a lot of strain on her with trying to take care of my household and my children on top of her household and her son on top of my 7 pets. You know, so
7 pets.
yeah, I got 7.
Are they different types of animals, or they're all this, like they're all snakes or all dogs?
I got 7 dogs and 2 lizards.
So it's 9 pets.
Yeah, 9.
Okay.
I also want to, kind of apologize to my children because being incarcerated takes me from them.
Sure does. Dad is not present.
And she needs me now more than ever. And I'm just kind of tired of dragging this case on. I don't see no reason to keep dragging the courts. I just want to get it over with. I do want to ask for a chance to show that rehabilitation work before incarceration. The last couple of months I have been incarcerated. I've been really focused on my mental health. I have had 2 suicide attempts, but I've been taking my medications. I've been talking to the counselors. I've been doing real well with that. I also just lost my mother right here in October. So I kind of been incarcerated since then. It's been a lot of strain on my grandmother. I'm kind of all she got. I just want to ask for a chance to really show that I've changed. I don't need firearms. I don't need to sell drugs. I just want a chance to walk the straight path. And I'm just asking the court to have mercy on me.
All right. Ms. Rio said you have 3 kids, an 11-year-old, that's a daughter, and she is with her mother where? In North Carolina? Okay. And so your goal would be to try to get custody of her?
When I first seen you on the first Zoom visit, she was already down here in Atlanta with me, but due to my incarceration, I had to send her back because I was kind of getting the wrong kind of feedback from her mother from me not being there. So like I had no choice.
Okay.
But it's really not what I prefer. As a little girl, I don't see no reason why she should be having her hair undone, her clothes filthy, wearing her little brother drawers, things like that. My wife had concerns about if she was eating enough and stuff like that.
When you say wife, that's Miss Scott?
That's Miss
To make sure there's not another person in the mix, because Miss Scott may hang up on us if there is.
Miss Scott. It's just Miss Scott. And
Okay.
this was just recently over the weekend. So
Now you have 2
I have
7-year-olds.
2 7-year-olds. I have a 7-year-old daughter and I have a 7-year-old son.
And where are they?
North Carolina.
Also North Carolina. And then Miss Scott has a child.
Miss Scott has a child.
And that child is with what we call your household? I mean, like,
That'll be her household.
right, her household, but that's where you are allowed to stay or you guys don't live
We have
together.
separate households.
Okay.
So
your 7 dogs and 2 lizards are not in her household?
no, sir.
Who?
Well, they with her now.
I was going to say, you've been in jail for a minute, so those are some hungry dogs if they don't have. Okay. All right. So the 2 7-year-olds are also in North Carolina.
Also in North Carolina.
Same mother as the 11-year-old or different?
Different.
Okay. All right. You mentioned something about medication, but I don't remember. I thought I was following. Ms. Smith would have asked you if you're taking any medicine.
I take my medicines during the night rotation.
But it's
Yeah,
it's
sir.
prescribed for what? What's it supposed to help with?
Depression, PTSD, and anxiety.
Okay. And when you take it, it helps you sleep?
Yes, it helps me sleep. It helps my mood not to fluctuate.
Yep.
And it calms my mind. Like,
okay.
I have been through a lot. Like, I do have a firearm history, but I don't have a violent history. I've never used it to, hurt anyone, rob anyone, but I have been a victim of gunshot. So
there's your PTSD and your need for that medication.
I kind of be strict on my fiance about, not leaving firearms and stuff like that in the car because of situations like this.
Well, you will get out. You're not getting out today, but you will get out. And I hope you and Miss Scott continue to have a relationship. She needs to not have a firearm in her house. It may be 110% legal for her to have one, but if you guys are talking, it's going to catch up with you because she's going to forget that it's in a bag and that bag is with you and you're out of chances. You're asking, hey, could I have another chance? You're on chance 7 now or whatever we're at. And so you got to make sure you are insulated from firearms. And if people you care about that you spend a lot of time with, they have a gun, they need to not have it. if you're going to be in their household. So Ms. Scott, as a fiance, maybe someday wife, she needs to shed the firearms because something like this will happen. If you're driving a car and there's a gun under the driver's seat and you get pulled over, that's your gun. It doesn't matter if it's drilled on there. That's Fred Smith's gun. You're possessing it at the time, and that's what the charge is. It's not ownership of a firearm by a convicted felon. It's possession of a firearm by a convicted felon. Ms. Scott's gun, your uncle's gun, whoever's gun, if it is in your possession, your span of control, you get hit with it. So you will get out, and you just need to make sure, because you're telling me I'm done with the guns, they need to not be in your life through people who are in your life. The medication that you take at night, you took it last night?
Yes, sir.
Okay. It's not leaving you woozy or confused or anything right now?
No, sir.
All right. Anything else you want to add? I didn't mean to cut you off.
No, sir.
All right. Well, Mr. Suggs, I find that there is a factual basis for your plea, meaning that the state could prove that in April of 2 years ago, I appreciate this was a while ago, there you were again, 2 months after you had pled guilty, sitting in the Impala, selling drugs, you had a gun in the car, two things that ought not to have been happening so at all, but so closely on the heels of having pled guilty in another felony case. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about, not your first plea. And voluntary meaning no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Smith, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Rios?
Yes, Your Honor.
And Mr. Suggs, can we sign your name indicating your guilty plea?
Yes, sir.
All right, we'll do that. Ms. Rios, do you waive any due process notice rights that you and Mr. Suggs would have in connection with the revocation in case 22 SC 181049?
Yes, Your Honor.
All right, Mr. Suggs, I'm going to sentence you as follows. Let me get your indictment back up on the screen. First, you have spent 205 days in custody in connection with these charges. You've been in 3 different times. You were in for a little less than a month, bonded out, went back in for about a month, bonded out, missed court, had the bench warrant, and that was your big stay, your most recent one. If you add all those up, because you get credit for all of it, it's 205 days, which is about 7 months that you've been in connection with these charges. It sounds like, Ms. Smith, that the sentence in the 22 SC case must have been a time served or straight probation because he was out 2 months after. Straight probation? Okay, thank you. What I'm going to do, Mr. Suggs, in this case is sentence you on count 1 to 1.5 years to serve. Count 2 has to be 5 years and has to run consecutive to count 1. It'll be probated. And then count 3 will also be 18 months or 1.5 years to serve concurrent with count 1. So it's a total sentence of 6.5 years, where the first 1.5 are in custody. You get credit for the 7 months that I already mentioned. Special conditions of your probation: number 1, the fine of $500. Number 2, stay away from that Texaco in East Point. And then it's not a special condition, but you just need to know what you do. You gotta abide by the law, and the law is that you cannot have a gun in your possession at any time. That's what's tripping you up here. Obviously, no controlled substances either. I guess I'm going to add a condition that no one mentioned, but you helped me appreciate its importance. You're going to need to continue to take any medication that's prescribed. So I hope when you get out, you stay on the medications you're taking. I mean, the exact prescription may change a little bit because they may have a different type through Grady or Mercy Care or wherever you go to get your meds. But if a doctor is prescribing them to help you stay calm and focused and in control of the things you do, then those medications are part of your probation. Okay? I will set a behavioral incentive date of, it's a little complicated because you're going to serve a little more time, can I set a behavioral incentive date that is 3 years after his day of release, or it needs to be in the final disposition a specific day?
If you want, I can mark it on my case sheet, but also, you can also put it on.
But what it has in the order typically is your behavioral incentive date is April 10th, 2028.
Yeah, the tricky part about that is, you know, actually,
Yeah, okay, I'll just set a specific date. I'll just push it a little further out. A behavioral incentive date is something where if you've done everything you need to do, your probation can end early. You're 30, you got all these people who depend on you, kids, pets. I don't know that Miss Scott depends on you so much as you depend on her, but you guys care about each other. And so you've got all sorts of good reasons to do the right thing going forward. It's not easy to do. And in the same way that all these people depending on you, they could make you, man, I'm not making enough hanging up chickens in this cold building. And so I got to make a little on the side. You just need to make sure that little on the side is because you're doing car detailing or landscaping or whatever you want to do. That's legit. It needs to be a legit hustle. Because something like what was going on at the Texaco, if you get scooped up for it, it all comes crashing down. So I'll set a behavioral incentive date of May. I'm just trying to think of how to do the math. November, December 1st of 2029. So that is 3.5 years from now. You're going to be in custody a little while longer. You are parole eligible. These are nonviolent offenses, so you will parole out at some point. You got a messy criminal history, but I'm guessing you will. Don't take my word for it. I have no say on parole. Your criminal history makes it less likely you get parole. The nature of these offenses makes it more likely that you'll get parole. So anyway, your behavioral incentive date is that date in December of 2029. You'll definitely have been on probation for a few years by that. Ms. Smith, anything else from the state?
Nothing further, thank you.
Ms. Rios?
No, thank you.
Now, this is before a final plea. The route has been a little tortured because it was in non-complex and it came here. And so you and Mr. Suggs can talk. Mr. Suggs, you're free to say no thank you to this sentence because it's more than what Ms. Rios asked for. It's less than what the state asked for. But if you want to say no thanks to the sentence, you can. But before you consider it, let me tell you the last piece in here. We need to handle the revocation in 22 SC 181049. And what I plan to do is revoke 18 months, a year and a half, with credit for the 205 days that you've served, and then close that case out so that you'd be on probation in this case when you are released from the Department of Corrections. Okay?
Okay.
So revocation is the same duration as the custodial part of this sentence. They'll run concurrently with each other, and then that case closes out.
Okay.
Do you need to talk about it or you want to take it? Or you want to go talking about it?
Yeah, we'll talk about it.
We'll talk real quick. Okay.
Your Honor, he accepts the plea.
Okay. Mr. Suggs's reporting instructions are just 48 hours after release. Where will you live when you get out? You mentioned 2 households.
Currently, I'll be in Atlanta.
Atlanta?
Yeah.
Fulton, Atlanta, or DeKalb, Atlanta? Okay. Do you know where the Fulton probation office is?
Yes, sir.
Where do you think that is?
Memorial Drive.
Still there. It'll be there when you get out. You got to report there within 48 hours. So when you are released, hug Miss Scott, pet the dogs. I don't know what you do with the lizards, but make sure that you get to probation within 40 hours. They know when you get released because you'll be released to parole, and probation and parole are the same team. And so you'll need to make sure you sign in there. Okay?
Yes, sir.
Any questions about anything?
No, sir.
Mr. Suggs, you got a lot good things in your life that you can move forward when you get out. Kids who need you, a significant other who wants you around. I think if you stay with the medication regimen and the kinds of things you told me, maybe your fourth decade will be different than your first three.
Yes, sir.
All right, good luck.
All right, thank you.
Ms. Rios and Ms. Wood, anything before we break for lunch?
No, Judge.
Ms. Smith?
Are we doing King?
I don't know that he's here, but I need to give everyone else a lunch break, so we will do Keen. He will just roll over to the afternoon calendar. Great. So I will mute things here.
Thank you so much. I appreciate it.
All right. Sorry, everyone, for the late start. I got pressed into duty as chief in a meeting that wasn't on my schedule. But it became our collective schedule. It's over. But Ms. Walsh was there, so PDs were well represented, as was Mr. Bond. So we had someone from the DA's office. We have another plea and arraignment calendar, and we had a bond calendar, but that is done because Mr. Jerome can't be here, and the lawyer for Mr. Williams withdrew, and we have a revocation calendar. Okay, let's call the calendar, see who is here. Position 1 is Lytanza Robinson.
She's mine, she's in custody.
She's here. You did a waiver, but we'll bring her out.
We are working, Ms. Smith and I are.
Maybe working it out. I saw the charge. I thought maybe this could work out.
There's some documents that I need to get to Ms. Smith about proof of incarceration.
Okay,
So if we can't handle it today, then maybe later this week.
okay.
But
I'll still meet her. I mean, we'll talk and then all right, we'll do that in a second. Robert Davis
he's mine.
in custody.
He had some sort of medical emergency this morning.
Uh-oh, did he not get brought over?
I'm not sure, but I don't think if he was brought over, he's no longer in the building.
Oh.
According to Deputy Gordon.
Okay, so we need to reset.
Yes.
And he has a revocation that needs to be dealt with as well.
Yes.
Okay. Deputy Gordon? I don't know if you can quite hear through that thick door.
Oh, okay.
Hey, I just need your ear for 1 second. Robert Davis, did he have to go back?
Yeah, he did.
He was
Never
here,
made it.
he never made it, so we need to reset that. Okay. All right, Barry Wells, who's here again.
He's here and I think, is that one going to Richardson?
Yes, I believe that this case will be transferred to what judge?
So, Judge, he has his calendar with Judge Richardson for probation revocation.
In June.
Yes.
Yeah.
I had recommended that if we could, well, it was on here, they have a new case here.
Yeah.
But, the court officer, she is very adamant on having that revocation. And so, Ms. Smith suggested that if we could send a new case there as well.
Interesting. Okay. So I should check, or Ms. Nelson should check with Judge Richardson's team to see if they'll take this. And I'm remembering now some of the back and forth. Given what Judge Richardson was discussing about the revocation, this could probably be resolved in connection with that revocation. Ms. Smith, would you have any objection if Mr. Wells's case moved to Judge? I don't know that she'll take it, but if she did take it, you'll be all right?
Yep, no objection.
Okay, and Ms. Wood?
No objection.
Okay. But he's here now. Should we not arraign him or we should just hold off?
I mean, I can do either. I know I met with him already. He is aware of what might be happening, so.
Okay. How about, I'm gonna ask Ms. Nelson to reach out to Judge Richardson's team real time to see if they will take Mr. Wells's case that's position 3 on our calendar. And if the answer is yes, then I'll just tell Mr. Wells, everything's gonna be consolidated there. If the answer is no, it should be frustrating, then we should arraign him today. Okay, all right, James Weems. I think that's who you were just asking about.
Yes, I haven't talked to him. I wasn't sure if maybe he's in custody since I haven't been able to see him, but when I checked, he was.
He has 2 cases.
Yes, Your Honor.
Okay, no Mr. Weems. All right, and it's late, so I'm assuming he's not showing up. I don't think we have anyone on. We have not him. We have some people, but not that name. All right, Ms. Smith, bench warrant for Mr. Weems.
Yes, Judge.
Jamal Williams should be in custody. And I have a question mark bond hearing.
Yeah, well, I heard from Ms. Nick, she said that, because of the late notice of needing to do the bond, she would ask for a reset to be able to reach out to the victims.
Okay, I figured given the charges, this would be one where contact with the victim was important. And I think there was some question about whether this was on for plea and arraignment, but maybe, I don't know if it was a last minute bond motion or it just didn't hit Ms. Nelson's radar.
I think I filed it maybe 5 days or 6 days ago. So
Okay, after the calendar was published. So this calendar went out as a plea and arraignment calendar. I'll still chat with Mr. Williams. You've already done a waiver, but I'll let him know we'll have a bond hearing soon. Okay. Mr. Price.
I already filed a waiver. He had other cases on here.
Yes, you've done a waiver in 2 and he has a final plea coming up in May.
Yeah, I told him we're gonna just take everything on the final plea.
Okay, so you've done a waiver in both. I'll let him know he's coming to final plea. Okay. And then we've got Jamal Corridors.
He's mine, he's here. This will be a non-negotiated plea.
Okay. And that's Ms. Willingham. And then on the revocation calendar, we have Randy Manuel.
Judge, he.
Yeah, he's in Collinsville right now.
Okay.
He's got court right now. That's a busy day.
So probably an arraignment. He's got a new case, or yes, he's got a new case in Carmel, and then he had a prelim this morning on a different unindicted case.
Yeah, I noticed he has 226 PIs. One is now indicted, so that would be the Carnesale business? Okay, because the warrant I have for him is new charges, drugs, and messed up car. But that was Monroe County, so, oh, this is right. His warrant's from 23. Wow, Mr. Manuel, okay. Ms. Williams, you're here for Mr. Manuel.
Yes, Judge. My understanding is that there's new convictions. One of the PI cases has been indicted, and Mr. Manuel is not here. So.
Well, he's in the building. He's in Judge Carnesale's courtroom right now. Do you want us to get him here when he's done there or reset this? Okay, do we have a hold on him? I don't want him getting out with all this. So there's a probation warrant, whatever happens with all this other stuff. Okay, have you had any discussion about whether there need to be an evidentiary hearing? Because I could reset it for not too far out if this is going to be one where it's just a debate about what the revocation should be. But if it needs to be an evidentiary hearing, then I should set it a little further out because then Ms. Williams would need to get some witnesses here.
I was unable to see him at the jail last week, so I've not met him yet.
Okay, then we'll just reset and do it all over.
Thank you.
Yep. Then there's Antoine Smith. Ms. Rios, your case?
We are ready for a probation revocation.
All right. And then Ms. Mann, Danikia Mann, who I feel like we were just with.
We're ready on a revocation on that as well, Judge.
Okay, and Ms. Williams, you've got Ms. Mann, and Ms. Willingham, you've got Mr. Smith?
I have Mr. Smith.
Oh, all right. It says Willingham on here, but Smith it is. Great. Okay. All right. Then why don't we knock out a couple of unless you guys had something you needed to do first, just the people are like, okay, you've waived arraignment.
That's fine.
All right. So maybe Ms. Robinson is still a plea? You're working on getting, so we'll hold on that. Let's bring, oh, we don't know the answer. Hold on. Does anyone have the case number for Mr. Wells's revocation? Please.
It is 23 SC 186206.
186206. Okay. So we'll hold on that. How about Jamal Williams? Can you bring him to the door, please? Thanks.
Oh, thank you.
Okay. Got it. Thanks. Hey, Mr. Williams. I'm Judge McBurney, and I wanted to let you know what's happening with your case. Ms. Rios has already filed a waiver of arraignment in your case, meaning she entered a plea of not guilty on your behalf. So I'll get a scheduling order into the docket, which means the state will provide discovery and your case can start moving forward. The one piece we're not able to tackle today is the bond hearing. Ms. Rios did file a bond motion, but she filed it after this calendar went out. So the state didn't have notice that today was a bond hearing. And you can understand why, given what the allegations are. The state wants to make sure that the complaining witness, alleged victim, has an opportunity to be told about the hearing. And then if that person wants to be heard, could appear on Zoom or be here in person. So we're going to keep moving your case forward. We've done the waiver of arraignment, and we'll get this on the next notice calendar so that we can do the bond hearing. All right? That's the plan. Any questions? All right, we'll see you soon. Can we bring Mr. Price next? So Ms. Willingham, you'll start outreach to, are you handling the? Ms. Nix? Okay. You told me that before. Hey, Mr. Price, how are you? I'm all right. So Mr. Price, you have two new cases that we are going to speed up and have them catch up to your older case. In 21 days, you're going to be back here for what we call final plea on your older case, which is kind of the last day. If you want to work things out, you could enter a plea, but if you don't like the sentence you get, you can back out of your plea. I'm not saying you have to plead to anything, but that's what final plea is. In your new cases, you got one where you're charged with entering auto a couple times, and another one, I don't have the case in front of, what, do we know what the other case? It's just not on the calendar. You've got two new cases. They're going to catch up to that other case so that on that date, May 26th, when you're back here, you and Ms. Rios will be talking with the prosecutor about all three to see if you can work all three of them out. Okay? Any questions about that? No? I'll see you on the 26th. Wait 1 second. Corridors is a plea. That's it. Everyone else is coming out for something more substantive. So let me see what the lawyers want to do.
He is a bond hearing from this morning.
Oh, is Keen here now?
Yes.
Let's do that. I forgot to ask, is there anyone in the courtroom who thought there was going to be a case called and they did not hear that name called? Yes, ma'am.
Yes, Tom Cole.
Yes, Mr. Jerome is in trial in another courthouse. So his staff reached out to say that we need to reschedule it because he is stuck with a jury arguing some case. I think it's in Gwinnett. Don't quote me on that. All I know is that he is in the midst of a trial. And so all the things he had scheduled today in other courtrooms, he had to cancel. because of that trial. Trial always takes precedence over other things.
Telling him that if he did not show up again in your courtroom for my husband, that you will move with his past?
No, I'm not saying I didn't say that, but I know he's in trial. If it's time for Mr. Cody to have a different lawyer, we can certainly make that happen. He paid Mr. Jerome, so there's that financial thing. My guess is he doesn't have a lot of money right now since he's sitting in jail, so he might qualify for appointed representation. But I can't today pull Mr. Jerome off because Mr. Jerome actually has a valid legal excuse for not being here. And I saw the list. He had a bunch of places he was supposed to be. But if you get pulled into trial by some judge, you have to cancel and then we reset it. All right?
Thank you, Judge.
You're welcome. We're going to do Mr. Keene. He was from this morning. Miss Curley? Hey, Miss Curley, I'm signing this. You're good to go. I'll get it to the deputy and he'll get it to you, but you qualify. So you know where to take your paperwork once I sign this? All right, well, good luck with everything. You don't have any boys, all girls, huh?
The last two are boys.
Oh, those are boys?
Yeah, that's why I had to write their name on the same line.
Oh, Crew and Co. Okay, it says daughter next to there, so I didn't know that. I won't tell them you said that.
Not going into this, it's a trap.
You get, that needs to go to Miss Curley. Thanks. All right. Good afternoon, Ms. Rivers. You ready to get on the record?
Yes, I am.
Great. We are handling position 5 from this morning's calendar. It's 26 SC 000-991, State versus Jeffrey Keene. Good afternoon, Mr. Keene.
Yeah, well.
Mr. Keene is here in court with his lawyer, Ms. Rios. The state is represented by Ms. Smith. And Ms. Rios, as I understand it, you've done waivers. Mr. Keene has 2 cases. One, fleeing and attempting to elude, and the other is obstruction.
Yes.
You've done waivers in both, and Mr. Keene has a bond in the obstruction case, which is from last year. And we're going to talk about bond in this newer case. Okay, so Mr. Keene, that's all we'll be doing. I'll hear from your lawyer about the case and your situation and why you should get a bond or get a lower bond, whatever the situation is. I'll also hear from Ms. Smith, who's the prosecutor seated behind you and to your right. And I may get a little criminal history information, if there is any, from someone who's on the Zoom call. And I'll let you know what I'm going to do. When you are ready, Ms. Rios.
Yes, Your Honor. Mr. Keene is 26 years old. He was working at setting up arenas at like State Farm, different arenas doing production and setting the stage.
He has a 2-year-old child who he financially supports. He also takes care of his mother who has cancer. His grandmother passed recently, so he is responsible for the total, was responsible for the total care of taking care of his mother. So he needs to be out to financially provide for his child and care for his mother. He did complete high school. I think he only has 2 cases. He doesn't have a lot of history as this case and the case that he was, the obstruction case, I believe. So I'm asking for him to get a bond on, so he doesn't have a bond on the entering auto. I believe the other charges he does have a bond on, but they're still kind of high for him to be able to make. So I'm asking for the breakdown to be on the fleeing 3K, on the entering auto 1K, on the reckless 500, and the seatbelt violation 500. Me and the state have been trying to work this case out. Once I get discovery on this case, I think we will have a global resolution. But just not sure how much time that would take with everything going on with the court calendars and the of not having court maybe in the month of June. So I just wanted him to get out so he can continue to take care of his mother and his child.
Okay. Mr. Keen, your child is a boy or a girl?
I got a boy.
And he stays with his mom?
Yes.
And your mom is not well. Who is taking care of her? You've been in now for almost 3 months. Who's been taking care of her?
My uncles and my brother, they're looking after her right now, but I was mainly the one taking.
Okay, but your uncles, her brothers are around to help some too?
Yeah, they're around, but they're working and stuff like
Okay.
that.
All right. Where'd you go to high school?
I went to KIP.
All right. Ms. Harvey, do you have any criminal history information on Mr. Keen?
Yes, Your Honor. He has 9 cycles, does not appear to have any felony convictions. There's a 2025 NOLO for misdemeanor theft by shoplifting out of Cobb County. There is an arrest, Your Honor, out of Clayton County from December 19th, 2025 for 3 counts of possession of a Schedule 1 or 2 controlled substance and 2 counts of possession of a Schedule 1 controlled substance. There was no disposition listed for this case, Your Honor, and nothing further to add.
Thank you. Ms. Smith.
Yes, Judge. In this case, the state is not opposed to the defendant getting a bond. We would be asking for a $15,000 bond. I think currently in this case, the fleeing and eluding has a 5K bond set, and the reckless driving has a 5K bond set. The only one that does not have a bond is that interference with government property. And in that case, the state would be asking for a $5,000 bond for it to equal up to $15,000. I think the main concern for the state in this case is the defendant being potentially a danger to the society. What happened in this case is the defendant was fleeing from officers, and not just fleeing on an interstate, but in a crowded area where there was a lot of traffic, increasing in speed and also trying to get away from the officers. While also trying to get away from the officers, he collided with one of their cars and then continued to then drive away from them to the point where he did get away and they lost visual and had to do an investigation to apprehend the defendant in this case. So again, the state is not opposed to setting a bond in this case, but we would be asking for a $15,000 bond.
Do you know if Mr. Keen would have been out on bond? Hey, Mr. Jerome, are you coming back?
Yes, Your Honor.
Good.
I'm actually about to just call my client's family.
Please do. They were here and I told them you were in trial because that's what your staff had said. And they were sad and left. So you're welcome to step out. I just need to make sure you were coming back. They seemed very, very anxious to have the bond hearing.
Yes, and I wasn't sure if the court had reset the hearing. We didn't get any notification, so that's why I appeared anyway.
Great, you're here. So see if you can track them down. They can't be very far. They left 5 minutes ago.
All right.
Okay, sure. Sorry. Would Mr. Keen have been on bond in the 25 SC case when this happened? I can look it up in a second. I just wasn't sure if you were familiar with the chronology.
I can double check that, Judge.
Yeah, he would have to have been because he was out. So he got, yeah, I didn't realize how, it's a 25 SC indictment, but it's conduct from March of 24. And he got a $12,500 bond in that case in March of 24. Okay. All right. Anything else, Ms. Smith?
Nothing further.
Okay. Just looking at one thing, Mr. Keene, then I'm gonna come back to you and your lawyer. Okay, anything else, Ms. Rios?
No, Your Honor.
All right. So, Mr. Keene, I am not going to change your bond right now. I know that your lawyer and you are close to working things out. That's going to be probably your most immediate way to change the situation. But given that you were on bond for the obstruction case when this happened, I'm not a big fan of putting you back on bond on the heels of what these allegations are. So I'm going to deny bond, but I will encourage Ms. Rios to let Ms. Nelson, who is my litigation manager, know. I'll hear from you in just a second. As soon as something's moved with this case, so we can get your case back on the calendar. Ms. Rios is going to get discovery in the next few days since she filed the waiver, if she hasn't already. And then she can meet with you to show you what state has and doesn't have, and you guys can talk about it. But you wanted to add something.
Yes, I wanted to say this case was going like on two or 3 years ago. And this case, I really never got this be in court about this last case, previous case. I was just
You're saying that, so you got two cases. One of them is the obstruction case. You're saying that one is from a few years ago.
yes.
It is?
I was at work and
Well, I don't want you to talk about what happened in the case. I'm
I
not,
was just saying it was like around 2 or 3 years ago when I was at work, but I just wanted to put that out there.
okay, I got it. No, I hear you. I've looked at the timeline as to when the different things happen. But we're going to keep things as they are right now, and I will wait to hear from Ms. Rios if this case is moving. Otherwise, we'll keep it moving. You'll be back in court for other things as the schedule dictates. All right? Thank you.
Okay, we'll talk as soon as I get discovered.
All right. What do you have, Ms. Williams?
Your Honor, I have the case with Miss Mann, Anikia Mann.
The revocation.
Yes.
Okay. Is that it?
Yes, Judge.
Ms. Wood, you ready to do that?
Yes, Judge.
Okay, can we bring Ms. Mann out, please? Are you Detective Toller? I haven't forgotten you. Okay. We'll get to it.
Are you there? What? Look at this.
This is the one case I don't have.
Oh.
Let me check before I say I don't have.
You're not, are you?
That's my mommy address.
Okay, write down, yes, because I need to get it to probation. And your best phone number.
Ms. Simpson, I don't have, unless it's in my lengthy list of emails I haven't read today, a warrant or a petition for Ms. Mann. If you could shoot me an email, please. Oh, wait, I have this. No, I got it, because I'm good. Yep, you sent it, 101.
You said.
Okay.
Remember?
Yeah.
Ms. Wood, are you ready?
Oh, yes, Judge.
And Ms. Williams?
Yes, Judge.
Okay, let's get on the record. This is 25 SC 000-934-01. It was a reindictment, State versus Mann, and Ms. Mann is here, represented by Ms. Wood, and Ms. Williams is here for the state. Good afternoon, Ms. Mann.
Hi, how you doing?
Well, I'm sad to see you wearing a blue jumpsuit again.
I know, right?
Right. Ms. Mann, you were sentenced not all that long ago, given some probation, a few conditions, and then this allegedly happened. In November, probation, you didn't report. Then they went to the address that we all thought was your address, and a letter was left or a note was left saying, hey, you've got to come to the probation office. That didn't work. Then they got you on the phone. Actually, hey, it's Ms. Mann. You got to come to the probation office. You didn't. Called you again. Hey, we're not kidding around about this. You didn't show up. And more recently, it sounds like you got pulled over for driving with no license. So, one criminal offense and then a whole bunch of playing hard to get, which you're not supposed to do when you're on probation.
Well, when I was.
You're gonna get a chance. I promise you.
Okay.
It's not me. I'll lecture at the end. I'm just letting you know
Oh, okay.
what I signed, and those are just allegations. And Ms. Wood, your lawyer, is gonna tell me, you know what, Ms. Mann is admitting, but we have some explaining we want to do, or if she's fighting this and we can bring in witnesses. What is the plan for Ms. Mann?
Your Honor, we are admitting to this, and I'm actually gonna let, I think Ms. Stone might be on the Zoom. That's the grandmother that you heard from back when we did the plea.
There's a Tamika Stone. Would that be the right person?
Mhm.
Okay.
So I'll let her speak, and I think she wants to share some stuff with the court, and Ms. Mann has plenty of family members here as well. Also, a representative from Motherhood Beyond Bars, Drew Umberger is here as well. They have connected with Ms. Mann while she's been in custody these 48 days. I will also let them share if the judge needs any more information, but it sounds like they're going to be supporting her once she gets out as well.
Will they be dragging her behind to the probation office?
Someone will, Judge. I think, so part of the issue, and like I said, Ms. Stone is more eloquent than I am, but there's been a lot of issues with her children. There's been various sicknesses, and then the license issue has made it hard for her. I've spoke to the family. They are gonna take her to take care of that traffic ticket as soon as she is released. And so I think Ms. Williams and I have been working on this case. I think we're all just rooting for Ms. Mann. Judge, she is expecting another child, and so we do need her to be able to do right on probation for herself and for her babies.
Remind me, what number will this be?
4.
4. How old are you?
I'm 27.
27. At this rate, you're going to have 38 kids before you're done being able to have kids. Okay.
So, Judge, I'm asking for revoke. She's been in 48 days. I'm asking for the court to revoke 45 days and reinstate. And I've got an address and a phone number and an email address I'm going to share with Ms. Simpson here shortly.
Okay. Well, let's start with Ms. Stone. Good afternoon, Ms. Stone. What do you want to share with me about Ms. Mann and what's been going on?
Since the last time we were in your courtroom,
Ms. Mann has really been taking accountability. Our relationship has gotten a whole lot better. She's been letting my granddaughter come see me. We started over building our relationship because we know it's important for the children, not just my granddaughter, but for the other two kids as well. She's also been trying to make sure that me and her mom and the whole family get together on one accord and just let it be about the kids and everybody get along. I see her trying and sometimes she be wanting to give up, but she keep on going. And I say, you can't give up. You can't give up. I think that it's just like a lot of stress on her and she needs some resources. You know, one being that she has been trying to find a job. She did tell me about, when she had to come to report, but a few things happened that was kind of like out of her will, but that's still not an excuse, but she takes accountability for that. Um, she calls me every morning while she's getting ready. And it's a lot. I watch her get those babies ready, taking them to their appointments, making sure she got to do what she got to do. She don't, you know, she don't have any other way, so she just makes sure she don't let it stop her. She do what she got to do when it comes to those kids, getting them to school, getting them to doctor's appointments, making sure that they spend time with me and the rest of the family. She has been trying, but I just think with a little accommodation, a little help, that it will help her instead of making it feel like she's drowning and no matter what she does, she's not moving forward. She just needs a little help.
When you say a little accommodation, what do you have in mind? What's the type of support you're thinking of?
Well, I just heard them saying that they were gonna go and pay so she can get her license back. But before then, because I didn't know what the plan was, I know sometimes there's the program to where she would be allowed to go and go back and take the kids to school, pick them up, or go back and forth to work without her being penalized. Also, by her being locked up, I know before then she would say I'm having a little problem with my rent because she had to do hair. She can't go get another job because everybody keep turning her down and she's trying real hard. So maybe a little rental assistance until she gets on her feet or something, because by her being locked up, that has thrown her behind. And if she's thrown behind, then that's not good for the kids, because now they right now they got a secure roof over their head, but I don't know what the situation is. I mean, she can tell you more, but just a little help, just something to where it doesn't feel like she's overwhelmed and too much is on her.
Okay, those would all be great things to have. Those aren't things necessarily that I'm going to be able to assist with, but I think some of the people who are here today are in a position to stand beside Ms. Mann and help in that way. They're all thoughtful requests on your part, but I was wondering if you had any ideas about what we could do that would ensure that Ms. Mann did things like show up for her probation meetings, because that's the space in which I have to move. It would be great if I had $1,000 care package to give to.
She gonna show up. She not gonna miss it no more. She gonna show up. She realizes she knew then that it was important because it really was bothering her, and she did try to get another appointment. I don't know how her and the PO kept missing each other, what was actually going on, but that was one of her biggest concerns. I don't think that she's gonna miss it anymore. Just give her another chance, please.
Okay.
You going and you gonna go, right? You not gonna miss it no more, right?
All right.
Okay.
Thank you, Ms. Stone. I appreciate
You're
it.
welcome.
Appreciate you being here and being around for Ms. Mann.
Definitely. I got her back. It's better for us to be together, and it's better that because if she's okay, then those kids are okay. If she's not okay, then nobody is okay.
It's a good point. All right, Ms. Wood.
Judge, Ms. Mann just wanted to give you some context, so I'm gonna let her speak whenever
Okay.
the time is right.
I'm ready for context.
Okay.
Okay, so when he reset me for those 3 times, the 5-year-old Michaela, she had a UTI. So, and that was from school tissue. So she was out of school for 2 weeks within the 2 times that he resetted me. Then the 2-year-old, she had a bump on her leg like a rising. So when I took her to the ER, they told me it was a brown recluse spotted, right? They couldn't do anything. So I had to take her to the big hospital, which is Piedmont Fayetteville. Next thing told me she had a staph infection. So that's when I missed the 3rd time that he scheduled me. So I was communicating with him all 3 times, but I couldn't do anything because I was in and out the hospital with the girls. So that's why I missed it.
You want to add another kid to that mix, huh?
I know. But that's what it was. It wasn't me intentionally like missing and not coming. I actually communicated with him a lot, but at the same time, he had a job to do as well. And he wasn't very understanding of the fact that I'm a single mother of 3 kids and being in and out of the hospital within 1 month time frame with 2 of them. It was a lot. On top of Makai
It is a
having
lot.
staph
I hear you.
infection.
You're gonna need to figure out a way to balance the two. And I think once you make that initial contact, it's gonna be a lot easier. But I think probation was wondering, is she for real? She's not coming, she's not coming, she's not coming. You've given me very good explanations as to why that wasn't happening. And everyone involved, probation included, wants your daughters to be healthy. And that's job one, is that they're healthy and well. But you can't ignore, and that's not quite the right word, because I understand you weren't trying to ignore. It just doesn't sound like you were necessarily like, all right, how about I come the next day or this or that, but we're gonna make it happen, because you're gonna need to report right after you get out. And I'll just ask if you didn't report right after you got out, I'll just sign another warrant. I mean, it's gonna be real simple. It's not gonna be straight from jail to probation, but you're gonna have this real small window. And there's not gonna be time for someone to get a staph infection in that window. Or someone else is gonna manage it for an hour while you go to probation and check in. Okay? Do you live in Fulton County?
Yes.
All right. So where are your daughters now?
They're in school.
Well, I mean, good, they're in school, but when they go home,
But they in school, I'm assuming.
okay. All right. So Michaela is 5.
Yes.
Who's 2?
Micaiah.
And then
Mackenzie, she's 7.
7. So you got a big old one, and then you're gonna have this teeny one adding. Okay. And then remind me, is there a father who helps with any of these, or it's you and your family?
It's me and my family. Michaela, the 5-year-old, her dad is deceased.
Okay.
And the 2-year-old, me and him have a no contact order.
Okay.
The 7-year-old dad, he helps out when he's able to, but it's what
Times are tough.
Right.
What about the 0-year-old?
The family back here.
Do you consult with the family before you decide you're gonna have another kid, that you're gonna make the family take care
I
of?
just found out when I got here. They didn't know.
Bet that brought a lot to their lives. All right, so you are recommending basically time served, Ms. Wood.
Yes, Judge. And if the court would like to hear about any of Motherhood Beyond Bars plans to help Miss Mann, I'm happy to have her speak.
I would, it's gonna sound bad. I'm familiar with another Beyond the Bars program, but it involves people working with dogs. It's very different. I'd like to hear a little bit about the kind of support that Ms. Mann will be able to receive and how she connected with your organization.
So we offer child birth education classes in 10 county jails. Fulton County, Atlanta City Detention Center being our very first one. When we found out Miss Mann was pregnant, she voluntarily wanted to come into our child birth education class. Along with child birth education also comes her very own program coordinator that is assigned to work with her to offer basically wraparound services, whether that be employment, verified second chance employers, prenatal care, mental health. We believe every mom that has been incarcerated does have some mental health, so we also encourage that. We offer lift rides for probation. We believe in full compliance and accountability. And we will help make sure that she gets there. And basically, the program coordinator is just, she's got a personal lived experience, so she can connect with Miss Mann on a personal level. And so that helps build that trust. And then we also supply diapers every month.
Wow, that's no small contribution. Right, okay. Well, thank you to you and your organization. That is an important resource, not just for Ms. Mann, but for the little ones.
For American generational person.
Okay. Yep, okay, well, thank you. Ms. Williams, it sounds like there are some forces coming together that might prevent this from happening again. But Ms. Mann certainly didn't get off to a great start with probation after I think the state was very open-minded in how it approached resolving the case. What are your thoughts about what ought to happen?
Your Honor, I will start out by saying that Ms. Stone called me several times to say exactly what she said just now. She believes in me very deeply. I could hear the joy in her voice because she was able to see Michaela. So thank you.
Thank you.
So, given that, it does sound like Ms. Mann has lots of family support. It sounds like there are also some wraparound services that are coming. So, Your Honor, I would agree with probation's recommendation. I would agree with Ms. Wood. I also believe that Ms. Wood may have an additional solution to propose to Your Honor regarding the employment issues. And the state is well aware of that and has no objection. We leave it in the hands of the court if you are willing to do that. But I do want to say that it seems to me that Ms. Mann's children are very bonded with her. They do want to be with her. And I would just echo what Ms. Stone said. This would be another chance.
Okay.
Thank you, Judge.
I must have missed the thing about employment, other than that Ms. Mann has 3 small kids, so having a job is tricky, but what's the employment?
I think, Judge, if the court will consider it, I will present an order to seal, and if it's apparent somehow.
Oh.
Because of the re-indictment, something is showing up when she's looking.
Got it. She's looking for a job and they say, what's going on? But this is a first offender situation. Okay.
Yes.
All right. I'm happy to sign more sealing things if we need to do that. Ms. Mann, you need to understand that, one, you are blessed to have these people who are here for you, family, support from organizations that try to prevent recurrence of crises like this. You're on super thin ice with the first offender. You got a first offender sentence, and here we are just a few months into it, and we're already talking about, gosh, probation wasn't working out. First offender will protect you from having some of these employment challenges that you're running into, but you don't get to keep first offender if we have to keep talking about probation didn't work for this, you got arrested for that. In particular, the arrest stuff, technical violations, you're a little late for a meeting or something, generally we can work through that, but you got to make sure you've got a license. If you don't drive, walk, take a bus, something. But it's not okay to keep getting arrested while you're on first offender status. Easy for me to say, not easy for you to do, but you need to make it happen for your kids, for your family. There are only so many times you can bring folks in who are going to say, Ms. Mann is great. And everyone's going to say, all right, let's not worry about what happened. This is one of those times when you sit in jail for 45 days is enough of a wake-up call. But next time, it's probably not going to be that simple. But let's hope there's not a next time. Okay? All right. Anything you want to add?
Thank you.
I haven't said what I'm going to do yet. Don't jump ahead.
Thank you.
Okay. I want things to work out for you even more so for your 3+1 kids. So what I'm going to do is find that you did violate the terms and conditions of your probation. by not showing up for your intake and this arrest, because that has nothing to do with your kid is sick. That's you driving when you shouldn't be driving, till you get the license cleared up. And Ms. Stone is right, there is a provisional license, but if you can get whatever your issue is with your license cleared up, that's actually simpler. It's hard to get a provisional license, and all that does is let you go from home to get kids to school and you to work, and not even to like the grocery store. So it's just a whole lot easier to figure out, hey, if I got paid $200 to get my license back, pay the $200, and figure out where you're going to get the $200. But it sounds like you have folks who are going to help you work through that. So I find you did violate the terms and conditions of your probation, and I will revoke 45 days of that probation. I will give you credit for the time you served. I will reinstate your probation, and I am directing probation to let me know if you don't report to probation within 48 hours of your release. Okay?
Okay.
So do you know where the office is?
Yes.
Where is it?
It's right outside ACDC 276 Memorial Drive.
It is. It's like 3 blocks from here.
Mhm.
If I could release you from right here, I would say, you know what? These people are going to take you straight there. But I can't. You got to go back. You'll be released from ACDC. And you've got 48 hours after your release to make it to the probation office.
Okay.
Okay? Tell them who you are when you get there. And they may say, hey, your officer's not here, but you will have done your intake.
Okay.
Anything else, Ms. Simpson, we need to talk about with probation?
Because they adjusted the intake process, so now they add more intake officers. So that is actually true. If Officer Sutton is not there, there's another officer that will not need intake.
Yep.
We should be Monday.
All right.
Tomorrow, I should be going.
Thank you,
Thank
Judge.
you. Thank you.
Good luck.
Ms. Moore.
Because it was pretty tight.
You ready to be a grandma again? You don't? Nope.
Thank you for being here.
Do you have another card?
I do.
Great. So if you give 2 to Ms. Williams, she'll give 1 to me, please. Yes. Thank you. Have you heard of this?
No, it's fabulous.
Yeah. All right, I need to quickly handle these warrants, and then we will turn to you guys talk amongst yourselves of what you want. Oh, except wait, this just in. We're gonna do this first, and then you guys can decide what we do after that. Mr. Stewart, hey, how are you?
Good, how about you?
We missed you this morning.
Yeah, I was incarcerated and I just got out this morning.
Oh my gosh, you got out this morning? Well, then I'm touched you came here of all places. Where were you in custody? You made it all the way from Douglasville to here? How'd you get here?
Somebody picked me up and they drove me out.
Okay.
Number 11.
Well, no bench warrant for you then. Ms. Wood, are you gonna be, I think Ms. Rios was chatting with him, but ultimately it'll be your case?
Will be mine.
All right, is this a waiver case?
There you go. Yes, Judge, I'll do it.
All right, so Mr. Stewart, I just need to take a quick look. All right, I've got an address of Silver Bend Overlook in Austell. Still your place? All right, that's where we'll be mailing things. You'll get court notices when you need to be back here. Well before you get something in the mail, Ms. Wood will be texting you or emailing you saying like, hey, does she have your contact information?
Yes, I do.
Okay, great. One other thing. your bond. So you got a bond in February of last year, and you are supposed to stay away from an Alexis Seaborn. Do you know who that is?
Oh, yeah.
Okay, is it easy to stay away from that person? Okay. All right, keep doing that. And if you're at that address, oh, and you still wearing an ankle monitor?
I gotta go get it put back on. I was actually going to do that when I figured out that I had court date, so I came down here before court closed.
They took it off when you went into custody and,
Oh, yeah, like 4 days in, 7 days, I don't know how many days.
okay. So were you going back to Second Chance or were you going to Douglasville to get your ankle monitor?
Oh, second chance.
Okay.
Chance came and cut it off.
Oh, they took it off.
They let them come up there to cut it off, but. Yeah.
Good. So Second Chance has it.
Yes, sir.
All right. So Ms. Smith, is this going to be your case?
It will be.
I'm going to ask you to check with Ms. Seaborn and look at the file. I'm going to give you a few days to do this. But Mr. Stewart has had the ankle monitor for a year and 2 months now, which is a little longer than our default. And it may be that he needs to go get it back on, but I'm going to tell him not to put it back on and wait to hear from you. And if you have concerns, obviously copy Ms. Wood on the email, but just let Ms. Wood and me and Ms. Nelson know thoughts about whether the ankle monitor should stay on. And that way you'll be able to let Ms. Seaborn know as well, hey, the judge is thinking about removing it because it's been more than a year, but she may give you all sorts of good reasons why it should stay on. I'm gonna let your lawyer know one way or the other. You gotta go back to Second Chance or the bond's being modified, and then I'll remove the ankle monitor condition.
Go back now.
No, don't go get one. Ms. Wood's gonna tell you, yes, go get one, or you don't need to worry about it.
I appreciate it.
Well, I don't know anything about you or the case. I just know that in general, we are taking ankle monitors off after 6 or 7 months, and yours was more than a year. Again, there may be a real good reason why it needs to go back on. And so if Ms. Wood sends you that email saying, judge said you got to get it back on, I have no doubt you're going to go to Second Chance and they'll put it back on. For now, leave it off, and then just look for that email from Ms. Wood. Ms. Wood, anything else in connection with Mr. Stewart's case?
Sure.
You'll get that waiver filed.
I'm working on an outro.
Great. We'll get a scheduling order in place. Ms. Smith, anything right now on the case?
No, sir.
All right, so you'll let me and Ms. Wood know after you've had a chance to look at the file and confer with Ms. Seaborn.
Yes.
Great. All right, that's it, Mr. Stewart.
All right.
How long were you in? This is like you're gonna go home for 35 days?
I had an FTA, they sent my court papers to the wrong address, so I just kind of had to see through it.
Huh.
Through the process.
All right, well, welcome home.
Thanks so much. Y'all have a good day.
Me too.
Yeah, I have this probation or.
Okay.
Oh, my God.
All right, now you guys talk amongst yourselves. I gotta send this email to Judge Richardson about Gary Wells, and then I'm gonna read these warrants.
May I be excused?
Yes, ma'am.
Thank you.
Just to talk to Ms. Robinson.
Yeah, you can see that.
Yes. No. Yes, it is. Bring with me, dude. You want to do your probation thing so you can leave?
Yes.
Okay.
I can't.
He does too.
Hey, you just saying, right? I just be weird sometimes. You want to be friendly, Smith? Oh,
And so why don't you call this your name?
yeah, I think it's like a 30 day.
Yeah.
The 30 days to avoid terminate in the own 9 days, I think.
Yeah, and they continue.
Yeah. About. The charger is like going about to die. It's okay. I'll definitely make it. We get a chance.
There's a probation revocation. Is he back there? Yeah, that's what's.
You just have one, right?
Yeah. Your key is a negotiator, not negotiator.
One's negotiated, one's not. But we're just disputing like the time. So it's like not.
I have the waiver and indictments.
Cool.
2 cases.
Okay.
It's 8.5.
So it's Mr. Conley on jail for the probation revocation?
Yes.
Okay. But he hasn't had the revocation yet, right?
No, that's what.
This he's picked up on the warrant. Okay, that is true.
So that we can do them all together.
And would you ask something? That may be released because of.
Because he has a medical condition that the jail can't sufficiently take care of. What he basically like diabetes, they're not giving him medication. He's been to the hospital 4 times. And the second to last time, he was there for over 2 weeks. And then they put him back in, even after all that, they put him back in regular population. They took him out the medical unit, put him in regular population. Only for him to the hospital again for supervision. So,
One of these.
I mean, he's on disability. He's not an ideal candidate. Yeah.
Okay, I got you. With that one, it's 2 cases. This one is the right one, the other one is 26. Yeah, 000586.
So, maybe next, he has this case.
Yeah, it's right here. You gave me 2 of the same.
Oh, that's good. That's fine.
Okay, cool. That's it. Okay.
Which case is it?
You'll take this one.
Oh.
And I work on cure in these cases.
Oh, okay.
Because she doesn't earn any.
Yeah.
Got it.
It's fine.
Who is that?
I think that's her.
I understand. Right?
He's out of there.
Yeah, this video is not good.
Okay, but could I make the argument that he was coming at her? Because he was walking at her too.
Whose apartment is that?
His.
Detective,
Yes.
you want to come on up here? Please?
I love this case.
And he's like kicking him out.
Yeah. But he was
So this guy gave up everything.
Is that like?
Yeah. Numbers and names and was he little or what? Why?
Once the homicide talked to him.
Why does he keep going at her?
Down in Monroe.
Or
Okay.
something else.
Yeah.
And then he went to go talk to him, he went on ahead and just.
Spilled it.
Yeah. He spilled it.
We don't see that so often.
Talked to.
Was he good? Yeah.
Talked to
Oh,
his parents.
Yeah. So these are young guys.
No, Thomas is 16.
Okay, that's
I
young.
talked to his parents.
What was his name?
We talked to him, and he said, he came in before, he talked to police and like, so
He's distraught.
Aaliyah.
Right.
That's why.
Yeah. 2 guns. One guy had 2 guns.
Yeah.
That's nutty.
Yeah. And
Okay.
I mean, you can make that argument
Right.
for sure.
Right. That's all on video.
Yeah. So with Thomas and
Luker?
If it went to trial, like, is there?
Yeah.
Yeah.
So
He's the one who should be talking.
yeah. Yes. So what I'm gonna do is the FBI vetted this case. So once I get that sounds like you.
Yeah.
Take it back. No. Their system.
Their stuff.
Yeah, their
Okay.
stuff because people.
Yeah.
I mean, we
Right.
could have done.
You could, but they'll do it faster and more thoroughly, and they'll be able to say he's actually in this room
Yes.
as opposed to this house.
Right.
Cool. All right. Well, do you swear or affirm that the contents of your 2 affidavits are true and correct to the best of your belief and knowledge? You need to sign there,
Thanks for raising.
I remember you from when I was in narcotics.
way back when.
Yeah.
Yeah.
All right.
On Thursdays, count.
Yeah. Because I can't remember. Remember that.
You're right, she can.
There.
Is that okay with you? It'll be quick.
Yeah.
So you can take them down. Okay.
All right. You are all set. Be safe with these.
Yeah, that's fine.
And
You feel like blacked out.
it goes as smoothly as can be.
I hope so too. Thank
Yeah, you bet.
you. Yeah.
But that's the problem.
All right, what are we doing next?
Can we do, let's hand the Robinson so that Deputy Gordon can take her and
Yes.
his man down?
Yes, what are we doing with Ms. Robinson? A plea. Let's bring Ms. Robinson out.
Okay, perfect.
With the C charger? Like. Well, I have my laptop charger in the hospital.
Oh, thank you.
If you have the C charger,
What's the C
what
charger?
laptop do you have?
Meaning you can use the iPhone or the Android.
Yeah.
How does it work?
Oh, yes, I didn't either. I saw someone else do it.
Love that.
Do one of you represent Prentice Mayo?
Oh, is that the murder?
Yeah, he's blown up. He's already filed a speedy trial demand
Likely gonna be mine.
after the indictment, so it's sitting there.
What kind is it?
Hmm?
Well, and I think he files if I'm representing him, actually, like.
No, the law's changed. It is not an automatic, no, I'm sorry, we're gonna get to your case in just a second. Your situation is much less serious. It's not a nullity anymore. A court needs to consider why he or she is filing it. And so, especially with a speedy, unless you were to countermand it and he were to say, yeah, I agree with it, then I have to look at it. I'll do that later. But we just got an email from the clerk's office saying, hello.
Our clients can file speedies and then we have to try the speedies because now they're deciding to file a speedy. You just have to.
You would need to get with your client and say, this is a bad idea and I'm going to withdraw it. But if a client files it and it's a legit speedy, I mean, just because it says demand for speedy trial doesn't necessarily mean that's what it is. But you may want to connect with Mr. Mayo.
He just got indicted. I gotta go talk to him.
Yeah, he was indicted on the 20th of April. Its case is moving plenty fast. It's moving speedy. But he has caught the attention of the clerk's office. He's already on like pleading number 20. You and Judge Ellerby can sort that one out. Ms. Robinson, appreciate your patience. Ms. Wood tells me that you are going to enter a plea in your case. Is that correct?
Yes, sir.
Okay, for that to work, well, let's get on the record. So it's 26 SC 000-312. And you are Ms. Robinson, represented by Ms. Wood here in court. Ms. Smith is representing the state. And Ms. Smith is going to put you under oath in just a moment, ask you a bunch of questions about you and your case. Make sure you understand the rights that you're giving up if you plead guilty. It's important that you let me or Ms. Wood know if you've got any questions while we're doing this. Will you do that?
Yes, sir.
Okay, Ms. Smith?
Thank you, Judge. Ms. Wood, is this going to be negotiated or non-negotiated?
Negotiate.
Ms. Robinson, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Latanza Equinetral Robinson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
39, some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes, I'm sorry.
Ms. Robinson, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
We are not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 3 years to serve?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge?
Yes, ma'am.
Can you repeat your recommendation, please?
Yes, Judge, 3 years to serve.
Got it. Okay, thank you.
Ms. Robinson, do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you are charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Ms. Robinson, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 26 SC 0000312, how do you plead to count one, financial transaction card fraud?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there has been some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Ms. Robinson. Your Honor, if this case were to proceed to trial, the state would show that on August 23rd, 2023, officers of the Atlanta Police Department responded to 776 Metropolitan Parkway Southwest, Atlanta, Georgia. That's also in Fulton County, in regards to a theft from a vehicle. When the officers got there, they spoke with William Rogers, who is the victim in this case, who stated that he was at this location renovating a unit at a townhomes community, and his vehicle was parked outside of the building. His coworkers observed a female standing next to his vehicle, but they didn't think anything of it at that time. However, Mr. Rogers later that day began receiving notifications about declined and approved transactions from his credit cards. He then went to his vehicle and he saw that his wallet was missing out of the, his wallet was left in the car. However, some of his cards and money was gone out of the wallet. One of those debit cards that were taken out of his wallet was used at a Murphy's gas station located at 864 Cleveland Avenue Southwest, Atlanta, Georgia, also Fulton County, and also the Walmart that's located at that same location. The officers then responded to the Murphy location, also the Walmart location, where they reviewed their surveillance cameras and they saw Ms. Robinson, who also matched the description of the person standing next to Mr. Rogers' car, making those illegal purchases off of the car owned by Mr. Rogers. And because of that, the officers obtained a warrant for Ms. Robinson arrest, and she was arrested for the charges we have before us. Those are the facts and circumstances of the case. Regarding the negotiated plea between the state and defense, we've agreed to a recommendation of 3 years to serve for financial transaction card theft. This recommendation kind of came from the history of the defendant here. I have an approximately 8 to 9 previous financial transaction card theft and fraud convictions on Ms. Robinson's GCIC, and also a couple of theft by takings and forgery. Because of the amount of similar transactions on her GCIC, the state in this case did file a recidivist notice and also came up with the recommendation of 3 years to serve. In this case, the state also talked to the victim in this case, and he told us that the bank made it right with the purchases. He said it was over $500 that was spent off of his card. However, the bank was able to reimburse him for the money that he had lost. So the state is not seeking restitution in this case. However, we're just asking for a sentence of 3 years to serve. And that is all from the state, Your Honor.
All right. Ms. Harvey, I have the recidivist notice, which lists actually 13 felony convictions in Georgia from a bunch of different counties. Did you have more than that? They extend from 2010 up through, the most recent was 2024 in Gwinnett County.
Yes, Your Honor, that's what I have. 44 cycles total. And then the only thing additional is a probation violation hold out of Cobb County.
Okay, as in that's current. There's
Yes,
currently, okay.
It is, Your Honor.
Okay, thank you so much.
You're welcome.
Ms. Wood.
Thank you, Judge. Ms. Robinson is 39 years old. She's a lifelong resident of the Atlanta area. She has 6 children that are currently living with family members. She does have some college education, and she, prior to all of this, worked at Popeyes. Your Honor, I was able to provide documentation to Ms. Smith and Ms. Nelson. She's actually been in custody since September the 12th of 2023. It started out in Gwinnett County Jail, and then she went to the Department of Corrections from June 2024 until September of last year with a Cobb visit
in there for a production order. And then she's been here with us since September of last year. So I did share all of that. We're just asking that she do get credit since September 12th of 2023. And then she understands that she's got the rest of whatever that math is left to serve.
Not much, but yeah. Okay. Thank you for that. How young is your youngest kid?
5.
So was 2 when you went into custody.
Yes, sir.
Your kid has grown up while you've been rattling around in the local jails. Tell me what, I don't see criminal histories like yours all that often. When I do, it's often connected with an addiction or something. That doesn't seem to be your situation. What do you think is going on? You've got 13, 14 convictions over the last 10, 15 years, all for the same kind of stuff. It's fraud related, not your credit card, not your stuff. And I ask partly because I'm curious. I'd like to get to know the folks that I'm working with, but I'd love to set up some kind of help. This won't be the case to do it because the recommendation is just custodial time, which you've mostly served. But what helps Ms. Robinson being able to, what's most likely to let you have your kids grow up with you on the outside rather than on the inside?
Taking my medicine.
Okay. When you don't take your medicine,
when I don't take my medicine, I get depressed. I think about my oldest daughter that I lost, and I go out and start hanging with the wrong people again.
Okay. What medicine are you taking now?
Remeron, Bruce Bar, Vistaril, Zoloft.
And they help with what? What's the diagnosis?
Depression, anxiety, ADHD.
Okay. And do you have a way to get that medication when you're not in jail?
Yes.
How do you do that?
My father told me about Mercy Care.
Okay. And your father is local? He's in the Atlanta area?
Yes, sir.
Okay. But you're getting that medication now.
Yes, sir.
When you take it, it helps you focus. Does it make you woozy or groggy in any way?
No, sir.
No, you feel like you're understanding what we're talking about.
Yes, sir.
All right. Okay. Do you have any questions about any of the things we discussed?
No, sir.
All right. Well, Ms. Robinson, Ms. Smith, you filed a recidivist notice, and is that in place for this plea? Yes, Judge. Okay. Ms. Robinson,
yes, sir.
I find that there's a factual basis for your plea. This did happen a long time ago. We all recognize that. But you also get credit for all the time you've been in because those are days in custody after this situation with Mr. Rogers's debit card. I also find that your plea is knowing and voluntary, which means the voluntary part, no one's forcing you to enter this plea. And the knowing part is that you've understood what we talked about. Do you agree with that?
Yes, sir.
Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Ms. Robinson, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
All right. Well, I will go along with the negotiated resolution. 3 years is a long time for someone's debit card. But my guess is at age 39, if this 3 years you've been not with your kids hasn't helped you turn a corner, then the solution isn't out there. I hope you stay on your medication when you get out and figure out a different way to move forward. It's not easy. 6 kids is a lot of responsibility, but hopefully you're up to it. It sounds like you've got some support. Your dad's out there. Do you have other folks to help you?
My mom, my brother, my sister-in-law.
Okay. And they're all in safe spaces to help you?
Mm-hmm.
Okay. Well, good. All right. Your sentence is 3 years to serve. I am sentencing you as a recidivist under both 1710(7)(a) and 1710(7)(c). Actually, it wouldn't, is the maximum 3 years for this? There we go, A and C. And all that means is you're not going to get paroled. And so your 3 years will end on September 11th of this year. So you got a few more months to go. You've got a hold out of Cobb, so you're gonna go back there. Every day you're in custody, this clock is running. So it's not, oh, you gotta wait till you're done with Cobb. I don't know what is in store for you in Cobb. It's probably related to your 2020 plea. And maybe they'll look at this 3-year sentence and say, hey, we'll revoke for 3 years, but give you credit for that time too. I don't know. I hope it goes smoothly for you. Do you have questions about anything?
No, sir.
Okay. Ms. Wood, anything else?
No, Judge, thank you.
All right, thank you.
Your Cobb probation stuff, okay? Okay. All right, good luck, Ms. Robinson. You're welcome. You're good.
Ms. Willingham, what do you have?
Orders.
Were we gonna do something else, Ms. Rios?
No, I didn't say a word. I'm gonna be here anyway, so it's really bad. Because we have a trial call.
Oh, we do, that's right. So let's do this. Let's do the coroner's plea and then Mr. Jerome, are we doing a bond hearing on Mr. Cody or is there a larger resolution?
Yes, no, we have a global resolution on Mr. Cody now.
Okay.
He waived indictment on his PI cases, and so the district attorney is accusing those cases. And we're gonna plead them all out.
Okay.
Not today, though.
Yeah, those accusations won't be done today.
Okay.
It may be that Ms. Smith can pull them together, but to then get the clerk's number, my guess is we can do it this week. I mean, I'm presiding, so I'm around. But I doubt that's today. But why don't you guys talk? And have you spoken with Mr. Cody? I want to make sure you get a chance to talk to him.
Yeah, I'll speak to him. All right, I thought that they could do the accusation same day. You guys can do that.
Why don't you guys talk more? Because Ms. Willingham is gonna engage on this next plea. So Ms. Smith will have a minute and you guys can talk scheduling. Ms. Wood, is this a negotiated or a non-negotiated plea?
It's non-negotiated only on the time served part.
And we're not far off.
Okay. Only on the important part.
But I
Okay.
expected that may happen.
Okay.
Not asking for.
Consent for bond on this? No, just. That's part of the reason why we push it. All right, that's fine. So, yeah, these things are not. It's on the.
Is this, where you plan on living?
Mhm.
Okay. Thank you.
So Judge Richardson has said yes to Wells's shoplifting. I'll tell him we'll do a quick at the door announcement and we'll handle it that way.
Thank you.
Okay, you're Mr. Quarters?
Yes, sir.
Did I pronounce it correctly?
Yes.
Okay, we're gonna get on the record in your case. It's 26 SC 001-714. Mr. Quarters is represented by Ms. Wood, and they're both here in court. Ms. Willingham is representing the state. And Mr. Quarters, Ms. Wood tells me that you are interested in entering a plea. Is that correct?
Correct.
Okay, Ms. Willingham's going to put you under oath in just a moment and then ask you questions about your case and about your rights. You need to answer those truthfully. You also need to let me know if at any point you've got a question. We say something that doesn't make sense or it's not going the way you and Ms. Wood discussed. Will you let me know?
Yes, sir.
Okay, then let's get started.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Jamel Daquan Quarters.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
38, 11th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Have you reviewed the indictment in this case with your client?
I have.
Do you waive formal reading of the indictment?
So wait.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
We do not.
Do you understand that you are entering a guilty plea to the following offenses? 1 count of aggravated assault, family violence, which has a minimum of 3 years and a maximum of 20. 7 counts of cruelty to children in the 3rd degree, which each count has a individual minimum of 1 day and a maximum of 12 months. Battery family violence, which has a minimum of 1 day and a maximum of 12 months. And obstructing or hindering a person from making an emergency telephone call, which has a minimum of 1 day and a maximum of 12 months.
Yes.
Do you understand that this is a non-negotiated or a blind plea, and the state will recommend to the court a sentence of an overall sentence of 5 years to serve 6 months? The special conditions would be no violent contact, complete the Families First program, complete family violence intervention program, complete a mental health evaluation and follow any recommendations, complete 60 hours of community service, and then seek and maintain gainful employment.
Yes.
Have you discussed this offer with your attorney?
Yes, I have.
And do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you do not accept the court sentence, you may withdraw your plea today, as we are only here today for plea and arraignment?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you on probation or parole for anything, anywhere?
No.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you further understand if you are found in possession of a firearm, you could be charged on the federal level?
Yes.
And I'm sorry, and that is specifically because this would be a domestic violence conviction.
Understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges to one count of aggravated assault, 7 counts of cruelty to children in the 3rd degree, 1 count of battery family violence, and 1 count of obstructing or hindering persons making an emergency telephone call in indictment 26 SC 001714?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today. Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Your Honor, if this case were to proceed to trial, the state would expect to show that on March 15, 2026, Sergeant McCourt of the Palmetto Police Department responded to 216 Green Spring Drive, Palmetto, Georgia, in Fulton County in reference to a domestic dispute. Upon arrival, officers met with Ishmael and Glanz, who made contact with a Black male later identified as Mr. Corridors. Mr. Corridors stated that he was in a verbal dispute with his wife, which resulted in him pushing her. Officer McCourt noted that he could see visible scratches on Mr. Corridor's face. Officer McCourt then went to speak with Miss Eland, who pretty much stated the same thing, except for instead of the altercation ending with him pushing her, that he had hit her in her bottom lip and that he started to choke her, which was determined by officers to be strangulation. She took officers through the house where they could see visible signs of blood. Her minor son was in the house and several other children who said to have witnessed the entire incident. The children corroborated the fact that their father hit their mother, even stating at one point that he was banging her head on the ground. This was a change of their original story, which they stated they did not see a physical altercation, admitting that their father told them not to tell the police anything or he would end up dying in jail. The defendant was then charged with aggravated assault, cruelty to children in the 3rd degree, battery family violence, and obstructing or hindering a person from making an emergency call. Ms. Eland stated that as the incident was taking place, she asked Siri to dial 911 when the defendant grabbed her phone from her and threw it. Your Honor, I had a very lengthy conversation with Ms. Eland. She was not initially happy when she learned that I would be asking for more in custody time. Even though it's not much that I'm asking for, she was not happy with that. They do have 8 children together, and she would like the defendant home to be able to assist. They've been together for, I believe, 15 years, which is their oldest child is 15. They are from New York, and there are some incidents there where she was also the victim. Although there has been a lapse in time since those incidents, I do have some concerns because there was a period of time where it appears that nothing happened. She did state that they are now here in Georgia, and it is just them and the children. And I told her that I believe they could probably take some time apart to kind of allow things to cool down. I do believe Families First will be very beneficial to them. It will be 8 counseling sessions. So although she is unhappy with the more in custody time, she does believe that the overall resolution that will include some counseling will be helpful. One of her biggest concerns, and I did tell her that I would make a note of it to the court, was not as much the ultimate charges, but more so she felt that she was not heard by law enforcement. She felt that, as many victims do in domestic violence situations, that law enforcement in this particular incident, she almost felt like her hand was forced. As I explained to her, though, that, you know, sometimes we have to step in to protect you when you are unable to do that yourself. And that is what I believe happened. It is not to negate her concerns about how she was handled by law enforcement, but I did want to at least, I told her that I would put that on the record, so I wanted to. She is unable to appear today, even virtually, because although she has a 15-year-old, they also have several small children, and that was her primary focus for today.
Got it. I want to make sure I understand the part about not being heard. It wasn't that she felt that your office wasn't listening. It was at the scene at the time, not what I'm more familiar with, which is the officers didn't take it seriously, but that maybe she's saying, I was telling them it wasn't so serious, but they seemed focused on, look, someone's going into custody today. It's not going to be you because you got the busted lip. So it's Mr. Corridors. Is that more along the lines?
Yes, Your Honor. She was hopeful that when law enforcement came, that they would just make the defendant take a walk to allow things to calm down. But instead, what she believes happened, and I was not there, so I will not purport to know one way or the other, but what she felt was that she basically, it was either she was gonna go to jail or he was. But obviously she had the physical injuries.
Right.
She had the more pressing injuries. The children confirmed that she was the ultimate victim, so they did take the defendant into custody. But that is what she felt. And initially, she was not happy with me, but it was because of that. And
Sure, you were an extension of that process.
Yes. And once I explained to her the difference between, you know, the officers coming out to charge and our office, and I explained to her that it was not that I was asking for just a straight custodial time. I would be incorporating some terms that I thought would be beneficial. She
Right.
was she was much more happy at the end of our conversation.
Or less unhappy.
Well, yes.
Right. Okay. Thank you for sharing that. Ms. Harvey, you knew what was coming. You turned your screen on.
Yes, Your Honor. There are 21 cycles out of the state of New York. This is the first arrest out of Georgia. Out of New York, felony convictions from 2020 for an aggravated criminal contempt, 2008 burglary in the second degree. In addition, there are misdemeanors out of New York, assault convictions from 2019 and 2014. In 2022, criminal contempt of an order, 2019 harassment in the second degree, and 2016 obstruction of breathing or blood circulation, all out of New York, and nothing further.
Thank you so much.
You're welcome.
Getting multi-state on us. I appreciate that. Ms. Wood.
Thank you, Judge. Mr. Quarters is 38 years old. He's originally from New York. They had just moved down here to Atlanta not too long before this incident happened. He has an 11th grade education. He has not completed his GED, although he wants to. He has done construction work and painting and other jobs of that nature, although he was unemployed at the time of this incident. I have explained to him that getting a job will be paramount, as that will also help him take care of the 8 children in age range from 3 to 15. I also spoke to Sierra. She told me pretty much the same thing. She told Miss Willingham that it was an issue, and she called law enforcement, and she was hopeful that they would just have them separate and take a breather. And instead, her vibe was that she felt that they were implying that either both of them would go to jail or one of them could go to jail or something of that nature. And so since she had the busted lip, then he was going to jail. She wants him home to help with the kids and obviously to pay bills. And she also shared with me that they had a 2-year-old daughter that passed away a few years back. And so that happened in the springtime. So it always brings back certain memories. And so I do think the Families First program will be helpful to all involved. Of course, our main issue, the reason it's a non-negotiated plea is because Mr. Quarters wanted to ask the court to do the time served portion to just be relatively time served, which is 52 days.
Right.
But otherwise, we ask that you accept the state's recommendation.
Okay, thank you. Mr. Quarters, tell me why your family moved from New York after all those years down to Georgia.
Felt like it was a fresh start for us. We had so many losses. Lost our sister, my grandmother, and my daughter all in the same month. So we figured we'd try somewhere fresh and just start over.
Okay.
And think overall the transition was great. I mean, we had a hiccup that shouldn't have happened. Man enough to own up to that. But I just really want to take care of my family and show them something different.
Okay. Do you have other family, or does your wife have other family down in Georgia, or this was completely disconnecting from your entire support system?
Yeah, just
with 7 or 8 kids.
Pick up and go.
Ooh, okay.
I also have 5 other kids that still live in New York. So
you have 13 kids.
I have 14.
14 kids. All right. That's a collection.
Yeah.
It sounds like you have struggled in the not too distant past with regulating your reaction when you and someone important in your life get into a disagreement. I'm not as close to New York law as Georgia law, but some of those misdemeanors sound like they would fall into the category of domestic disputes. Did all that involve, how do you pronounce your wife's last name?
Island.
Island. Did those situations all involve Ms. Island, or was there someone else?
No, it was someone else. It was kind of sleeping with this woman and that woman and everybody clashing. So.
Okay. That can happen.
Yeah.
Yeah. Okay. All right. Anything you want to add?
I'm just asking for a second chance. I don't plan on being in any other courtroom from this point on. So
I hope you aren't. You're getting up in age. You're still young, but some of this should be behind you. More important, whether you're 28, 38, or 48, you got 14 kids,
yes.
And you can take care of 0 of them when you're walking around in a blue jumpsuit. It doesn't happen.
Definitely.
So, all right. Well, Mr. Quarters, I find there's a factual basis for your plea. My guess is, as is often the case, not always, but often, there was some back and forth going on. The way it ended wasn't okay. One of the things hopefully you will take away from both Families First and the Family Violence Intervention Program will be a set of techniques that allows you to step back when you feel the temperature rising with people who are close to you and important in your life, so that your reaction ultimately is cool down rather than you put your hands on someone, because that's never okay. But I do think there's evidence that could support these charges if this case went to trial. I also find that your plea is voluntary, meaning no one is forcing you to do this, and it's knowing, meaning you've understood the things that we've been discussing. Do you agree with both those statements?
Yes, I do.
Ms. Willingham, can someone in my office sign the indictment for you?
Yes, Your Honor.
And Ms. Wood, can we sign for you?
Yes, Judge.
Mr. Corridors, is it all right if we electronically sign your name indicating your guilty plea in this case?
Yes.
We'll do just that. So, Mr. Corridors, lots of counts here. I am going to sentence you on count 1 to 5 years to serve 4 months with the balance on probation. Counts 2 through 10 will all be 4 months to serve. They will run concurrently with count 1. Special conditions of probation. Number 1, no violent contact with Ms. Island. That's a crime anyway, but let's add it in here. So not only would it be new charges, it'd be a violation of probation. Number 2, get your GED. You'll need to enroll in the GED course within the first 6 months of probation. So you get that rolling. Number 3, you'll need to complete the Families First program. Number 4, lots of programming. You'll need to complete the Family Violence Intervention program. You need to enroll in one of those also within the first 6 months. I want to manage the reality of you needing to work to support your family and needing to knock some of these things out. So you're going to start with a GED within the first 6 months, and then one of the 2, Families First or Family Violence Intervention program. Also, you get that started within the first 6 months. You don't have to finish it, but you get it started. You'll need to submit to a mental health evaluation, and if that good doctor says, hey, you'd benefit from therapy or medicine or whatnot, that treatment becomes part of your sentence. And I am all for community service, but I am even more for you working, getting your GED, and knocking out this programming and taking care of all the kids in your household. So I'm going to skip the community service requirement, only because there are not enough hours in the day, I think, for you to be meaningfully involved with all the things you need to be involved with. Anything else, Ms. Willingham?
No, Your Honor.
Mr. Corridors, the sentence I imposed is in between what your lawyer asked for and what the state asked for. The state's request wasn't unreasonable, and if you had less burden that you shoved onto Ms. Island by getting locked up, I'd probably go with the 6 months because of things you've done not too long ago back in New York to other women in your life. But I'm trying to strike the balance between shaking you and say, you're 38, don't do this again, and Ms. Island needing help managing this big old household you've got. So I came down with 4 months. Ms. Willingham told you at the outset, this is super early on in the case. If you want to say, no, thank you, Judge, I'd rather go to trial, you can step back from this sentence because it's more than what your lawyer asked for. I'm going to ask you to confer with Ms. Wood to say, yeah, it's not perfect, but I'll take it, or no, thank you. Let's move this case to trial. Okay? Ms. Corcoran, how are you? So I'm going to sign the affidavit so you can move forward. It's going to be complicated being a self-represented litigant in a automobile accident case. I'm not discouraging you from doing that. You 100% should go forward. Plaintiffs tend to have better luck lining up a lawyer because plaintiffs' lawyers say, great, I get 30% of whatever you recover. And you can always add a lawyer later on. You are not a self-represented litigant forever. This is how you're starting. Okay? Do you know what to do with the paperwork after I sign this? Go to the clerk's office and get things filed? Okay. All right. Deputy Gordon, you mind grabbing this? Sorry, close that door.
Thank you, Your Honor.
You bet. All right, Mr. Corridors, back on the record in your case. Did you have a chance to speak with Ms. Wood?
Yes, I did.
And what is your choice? Do you want to go forward with your plea, or would you prefer to withdraw your plea?
Move forward, Your Honor.
Okay. Last thing we need to talk about, you're going to be on probation down here in Georgia. Your household, it's in Palmetto, so it's Fulton County. Just barely, but it is Fulton County. You're going to need to get reporting instructions from Ms. Simpson. She is with probation. She is not going to be your probation officer, but she's going to come back and just get info from you and give you a piece of paper that lets you know when and where you need to be. Don't miss that. That's a hot date. You got to plug in with probation. Okay?
Yes, sir.
All right. Good luck
Thank you, Judge.
with everything.
Welcome back there.
Thanks, Ms. Willingham.
Judge, I actually was literally, as you said, the GED, I was thinking I should take off the community service.
Oh, look at that. Between the two, get that degree.
You were right.
Investigator Hernandez, I'm gonna read over these real quickly. I understand they're urgent. We'll get them going. Ms. Smith, how did you leave things with Mr. Jerome? He's gonna talk with his client.
Yes, it is my understanding that we'll be doing a probation revocation today and then doing a global for the two PI cases on Friday. Hopefully.
Okay, any reason we're not doing them all at the same time?
Well, he stated that he wants to be in person for the probation revocation, which is today, and then on Friday, he can only be virtual. So
Got it. Okay. All right. The revocation, though, doesn't involve witnesses. Is Mr. Cody stipulating to what happened, or you've got witnesses hidden somewhere?
So he's stipulating from my understanding.
Okay. All right.
While we're waiting.
Yes, Ms. Rios.
And Antoine, I don't like to call him Tremaine, that's the other. Antoine Smith, because everyone's agreement in agreement.
Yes, we can do that. And we can get Mr. Wells to the door. So when Deputy Gordon pokes his head back out, we'll knock out both those.
Also, the hearing tomorrow is not a hearing for
The revocation, you're handling it.
Yes, it's not a hearing though, it's just a,
He's just gonna take his medicine.
well, no, we all changed, they're agreeing, we came to a negotiating. The vote agreement, I gave them an affidavit of the person's gun it was, and we talked and they were agreeing to remote agreements. Now you're looking like you're not happy about.
Mr. Muse just has a long history here with guns, but okay, we'll work through it. Deputy Gordon, if you're able, Mr. Wells can come to the door and I'll take care of Mr. Wells.
Yeah, he's. Because the contract is in drops.
Hey, Mr. Wells. Good to see you. I just want to let you know how your cases are going to flow. You have a new shoplifting case here. Judge Richardson has your revocation. And based on how you and your lawyer and the prosecution in that revocation weren't able to sort things out, that hearing is going to happen in a little while, not today, but a few days down the road. And Judge Richardson has agreed to handle your shoplifting case then as well. So I'm transferring the shoplifting case to her so that you can have one judge, one resolution of revocation and the new charges. I just want to let you know. We brought you over today because I thought we would just do an arraignment on the new case and maybe handle the revocation. But Judge Richardson has said, no, she's handling the revocation and it's her case, so I can't take it from her. But she graciously said, but hey, send me the shoplifting so Mr. Wells doesn't need to be in two places. All right? Just want to let you know. You're welcome. So we're so Smith is the last thing.
Yeah. Yes.
Okay. Right, because we did man.
I didn't know what all you, so I just wrote all this important stuff down for him. So right there, just let him get it. Decide on it.
And I will also possibly send an email to her so that she will have it and she'll.
Okay.
No problem.
There you go.
Can I call her so that she?
We're ready for Smith?
Oh,
Yeah.
Okay.
Oh, I'm sorry.
It's okay. Are you doing your monthly? I stayed up till like 12 doing it. Then out the way.
Oh, no, I did April on Friday. I just keep up with May as I go.
Oh, that's a good idea.
Yeah.
I'm gonna start doing that.
Yeah.
Ad program. How long do I have to wait? Do I say that I go to Douglas?
Yeah, you still have to go to Douglasville either way because you have a hold. There's nothing still stopping that. You can't take off the hold.
Okay.
Mr. Smith? How you doing?
I'm doing all right.
Okay, we're gonna get on the record in your case. I actually have two cases for you, but only one is on the calendar. So I'm gonna get a little more information from Ms. Simpson. But the one on the calendar is 23 SC 186197. And you're here in court with Ms. Rios. We've got Ms. Smith here for the state. I think that's who will handle it, but I also have an 09 SC case that would very much be a Ms. Williams case. Is Mr. Smith still on probation for the 09 SC case?
You don't have a month and a few days remaining.
Okay,
So I'll add to both days.
we probably have all the right people here to handle that. Okay, all right, how much time is left on the 23 SC case?
2 years, 10 months, 10 days.
2 years, 10 months, 10 days. All right. Well, Mr. Smith, it is alleged in a warrant that I signed that in October and November of last year, you tested positive for cocaine. You were supposed to start showing up for drug screens. You didn't do that. Then you were supposed to go to the day reporting center and you didn't do that. So these are kind of technical violations. It's technically a crime to test positive for drugs because you're using, it's not the right way to put it. It's a crime to use drugs, to possess them. But we're mostly focused on getting you care and treatment. That's what I want to make sure is that if you're struggling with an addiction, I want to make sure that if there are resources there, you are taking advantage of them and not going to end up making some bad choices. So I'm going to start with Ms. Rios. Tell me, Ms. Rios, if Mr. Smith is admitting to these allegations.
He is, Your Honor. Well, he's admitting to some. So the issue was he said he reported to the Fulton County office and they told him he was supposed to report to Douglasville. And so he was confused of where he was supposed to go. So I understand the drug testing, but that he said he was trying to report. He wants to get help. He has a hold out of Douglas, so he's not going to be able to get help here because he has to go to the hold. And I encouraged him to tell, do they have a public defense office in Douglasville? They do. Okay, I encouraged him to tell his public defender there, then to do a referral to PAD. He's 50 years old. He's from Georgia. He has 3 children, 26, 25, and 4. He wants to kick his habit so he can take care, especially for the baby. So we at the state sent their recommendation, which is revoke 30 days and reinstate on the case that he has longer time on, and the 09 case to terminate. Let me just ask you go along with that recommendation.
So revoking 30 days would basically be time served because he's been in for more than 30 days. You're all right with that, Ms. Smith?
Yes, Judge.
Okay. So it would be revoke a month, reinstate in the 23 SC case, revoke a month and close out the 09 SC case. Do we want to add a special condition that is there a DRC in Douglas County? Because the home address is Douglasville, it's not Atlanta.
Yeah, his supervision is.
I don't stay there.
Where do you stay now?
Homes. I don't have no spot. That's why I was asking for the.
One thing is he doesn't stay there anymore. Right now he's homeless.
Okay. So that's going to make reporting more important, Mr. Smith, as you are figuring out where the roof is going to be under which you will stay. You need to keep probation notified. Hey, I'm here right now. I'm at this motel, or I'm at a friend's house, or I'm at this bridge. But they're not going to be able to find you. You don't want to be hard to find because it just means another warrant.
Yeah, I was reporting to them.
Good. They didn't say you didn't report. They said you were testing positive for cocaine. Then you missed some drug tests, and then you didn't go to the day reporting center. And so you could see they're getting concerned. You've got a need. They're giving you a way to address the need, and then you weren't there. When you get out, well, I guess you'll go to Douglas because you got a hold in Douglas County. When you sort that out, you'll be released in Douglas County. Do you plan on hanging out there, or?
I'm requesting to go to the PAD program.
Okay, which is back here.
Yes, so I can get my stuff transferred from there to down here.
Okay.
So,
all right, but you'll stay in touch with probation as you're figuring out where you're going to relocate.
yes, sir.
Have you met with anyone from PAD?
No.
Okay. All right. Well, when you're in Douglas County, you may want to do some outreach to PAD to see if they can come talk to you. All right, Ms. Rios, anything else?
No, Your Honor, thank you.
All right. So, Mr. Smith, in light of your violations of probation, which are technical violations, I am going to revoke 30 days in the 23 SC case and reinstate your balance. And in 09 SC 77, I think it's 856, this thing printed out real blurry, 77856, I'm revoking a month, and then I'm closing that case out. So you'll be on probation from Fulton in just one case. You'll be supervised out of Douglas County until you provide a new address. And if you end up being unhoused, but you're going to be in Fulton, you should go to the probation office in Fulton to say, I don't really have a place to stay, but I'm going to be in the Fulton area rather than out in the Douglas area. Okay, any questions?
No, sir.
All right.
Given the nature of Mr. Smith's dollars, and I'm sure he's not going to know. He still has the condition to complete the family violence intervention program. It was a condition of the original sentence.
Okay.
Would you remove that?
I think that makes sense. That's just going to be an insurmountable obstacle. And we could focus on drug treatment if you can plug in with PAD. So I'll remove the special condition that you complete the family violence intervention program. All right. If there's nothing else, what are Mr. Smith's reporting instructions? 48 hours after he's released from his Douglas hold?
Yes, sir.
Okay. Do you know where the probation office is in Douglas County?
Yeah.
Okay. So you got to be there within 2 days after. I don't know what Douglas County is going to do with you, but when they're done, you got to report to probation. Okay.
Yes, sir.
All right.
Thank you.
Good luck.
Thanks, Ms. Rios. All right, Mr. Jerome, what are we doing with Mr. Cody?
Your Honor, we're looking for the probation revocation hearing today. Mr. Cole, we're going to stipulate to the probation revocation and be heard on sentencing.
Okay, let me find. There it is. Was the bond hearing going to, that's the probation revocation case? You were hoping to get a bond in connection with a probation warrant because of the health concerns?
That's correct.
Okay, and we're turning that into the revocation hearing instead of the bond hearing?
That's correct.
Got it. Okay. If you've got Mr. Cody, he can come on out. All right. Hello, Mr. Cody.
How you doing?
I'm all right. Mr. Cody, we're going to get on the record in your case. It's 21 SC 178578. And we're dealing with a probation situation. I signed a petition for the revocation of your probation a couple months ago in February. And the allegations are, number one, in December of last year, you got arrested for having some marijuana and a gun as a felon and having a gun in connection with the drugs. And then somehow you got out because then in January of this year, you were arrested again, and this time related to having marijuana, but apparently no gun. So two different arrests. Arrests are not what's supposed to happen while you're on probation. Mr. Jerome, who has been trying to get you in here for an emergency bond hearing, tells me that what's going to happen now is that you are stipulating to the arrests. You're not necessarily pleading guilty to that stuff. That's for another day. But you are stipulating the fact that while on probation for possession of a firearm by a convicted felon, you got arrested for having a gun and drugs and then got arrested a second time for having drugs. Is that a fair summary, Mr. Jerome?
Yes, it is.
Okay. And Mr. Jerome, tell me what you are recommending I ought to do in terms of revocation.
Yes, Judge. So essentially, the sentence that Mr. Cody is serving now is going to expire in March 20th of 2027.
The sentence for the 21 SC case.
That's correct.
Okay.
For the 21 SC case.
Yep.
What we're requesting is the state essentially is going to ask for a revocation of the remainder of his sentence. What we're asking is that Mr. Cody be allowed to serve that sentence on house arrest. The reason why we're asking for that is because Mr. Cody is essentially dying inside of the Fulton County Jail. He's had kidney failure. He's had a diabetic ketoacidosis and a hypoglycemic shock while he was inside of the jail. He's had really low sugar readings, and they just don't have the proper diet for him and the proper treatment for him. He has a certain medication he's supposed to be on. We've notified the jail several times about it, and they just haven't given him the proper medication previously. Now they are, but they're not giving it to him in the proper interval. So they're not giving him as scheduled. He was released from the medical unit and into the general population, and then he had another episode about 2 weeks ago. He had to go to the hospital for 24 hours to be observed because of the issue. And those type of issues, you don't go to the hospital unless it's serious. And he's been to the hospital 4 times since January 21st. And
Are you back in the medical unit, Mr. Cody?
on the medical floor?
Yeah. Okay.
Yeah. So one time on March 2nd of this year, he went to the hospital for 15 days. His blood level was so low, they thought that he had brain damage. But essentially, it turned out he was fine. He had passed out in a cell. Nobody seen him. It was a cellmate that contacted the family, and then the family had to call the jail, and then the jail went and picked him up, and then he disappeared. No one could get in contact with him. Even I went down to the jail and tried to see him, and they wouldn't even tell me where he was or what was going on with him. Family didn't hear from him. They thought that he was dead for a certain amount of time.
But he was at the hospital?
But he was at the hospital, yes. They had taken him to the hospital. But they wouldn't let anybody know that. And even at the hospital wouldn't acknowledge that he was a resident there. And so it was difficult for the family, not even knowing where he's at.
Sure, I can imagine.
He was previously the victim of a robbery and gunshot, and he's on disability. It's part of the reason why he still occasionally gets these gun charges. He has this anxiety that he feels like he has to carry a gun with him sometimes. His family has really done an intervention with him, spoken with him. This time of being incarcerated, even I have spoken with him. The best thing for him is really to not leave his house. If he's at home, then he's not going to have that type of fear. He's not going to feel the need to carry a firearm on him, and he won't have these issues. He has a specific place that he goes and he gambles, not gambles, but they have slot machine that he uses legally. And when he's either traveling there or traveling home, and he travels by foot, that's usually when he's picked up. He says that it's usually the same officer he feels like is constantly basically picking him up and, seeing him. So that being said, Your Honor, he's not a troublemaker. He's not a violent individual. He's not a person that has any violent history. All his charges are always pretty consistent. It's usually drugs involved. And the drugs is because of the pain that he suffered. He uses the marijuana to kind of numb that pain. And then, the firearm, as I just spoke to you about. However, after his arrest in 2025, his wife would say that he hasn't had the firearm on him, but still he was arrested again in 2026 for the drugs again, which is partly because of the pain that he has. He's on disability, and now he's at risk of losing his disability. And if he's incarcerated for the next 10 months, then he will certainly lose that disability. And then that will put him and his entire family in a dire financial situation.
Why the entire family? I mean, disability benefits aren't enough to support a family. They're barely enough to support one person.
Well, and that's the thing, because right now his disability benefits are at least keeping him afloat. But if he were to lose those benefits, then the entire load would fall on his wife, because it's difficult for him to work or keep a job. And so now she would have to bear the load entirely by herself. Even with his incarceration now, it's only with the help of his sister, his mother, her mother, that she's even been able to sustain this long. And he still does have the disability, but obviously having to pay bond, get an attorney, everything else is difficult on them. If he loses the disability, then it's basically everything would be very devastating for him and for her. In addition to that, he does also have an additional case in Clayton County that's not quite as serious as the cases that he has here. It is another drug case in Clayton County. However, his probation there is going to be up later on this year. And we are already kind of working that out. So he's already served over 100 days. We believe in Clayton that he's going to have 120 days, and then they're going to release him back to probation.
Yeah, I'm showing that there may be a hold for him. Would that be the Clayton hold?
That is the Clayton hold.
Okay, so whatever happened today, whether it had been a bond hearing and I granted bond or it's a house arrest, Mr. Cody's next stop is actually Clayton County.
Correct. And in Clayton, he's not going to have that much time. So, right now, to be exact, I believe it's 108 days is what I saw today. So he would essentially have 12 days to serve in Clayton. And so that's why one of the reasons we don't want to prolong this any more longer, because he's not going to have much time to serve even in Clayton. If he's home, he's not going to be going to the stores. He's not going to be going out. He'll be on house arrest. His wife is going to be able to give him the treatments and make sure that he stays on his medications, which he hasn't had any of these. He hasn't had any of these issues previously while he's been home. So all of these, episodes that he's been having at the jail have only happened since he's been incarcerated in January. That being said, so that's what we're requesting. We're requesting that he spend the remainder of his sentence. So even if the court does revoke the remainder of his time, that the court allow him to serve the remainder of his sentence on house arrest. And he will have a sentence for the 2 PI cases that are going to be longer than this, but at least this portion of it will also be house arrest. One of the reasons, and just to clarify, I understand that they are going to indict those PI cases, and I already explained. And one of the reasons we want to do this quickly is because he's going to go to Clayton and he's going to get out of there and be done with that one. And we don't want to extend his stay in Clayton any longer than it has to be. If it gets done before then we can always, come in through Zoom or some other form and get it done quickly here. If those cases are accused on those other 2 cases.
Okay, thank you. Ms. Smith, what's your forecast as to when the PI cases would be accused? If you're going to do that, I mean, if we resolve this, then it's really not your case anymore, and meaning the PIs aren't, but if we're trying to wrap everything up together, my inclination would be to hold off on figuring out how I'm gonna rule on the revocation, balance of time in custody, balance of time on house arrest, until we've got the other two cases and we're coming up with a global sentence. Because Mr. Cody runs the risk, those PI cases, when indicted, wouldn't have a reason to come back here if we handled the revocation.
I spoke with Mr. Jerome and I told him that I could push very hard to get those accused by Friday so we can do a global offer. That way we can wrap it up all in one. I do believe that if we take care of the probation revocation today, we'll just have to
See where that goes,
Yeah.
then he's off to Clayton and who knows what happens.
Right.
Okay. All right. Well, setting that aside, what's your recommendation if all we're gonna focus on is the revocation?
Yes, Judge, in this case, the state is asking for the balance in this case to be revoked, which is 7 months and 8 days, because the defendant in this case took a plea back in March of 2022, was put on probation for the next 5 years, or 5 years, subtract 2 months to be in custody. And then we have 2 new cases with similar charges, drugs and guns for one of them back in December, and then drugs again in January. We do believe that there is a risk of the defendant reoffending in this case. And because of that, we are asking for the balance of the probation to be revoked. I do know that for defense, the main issue is if the balance is going to be revoked, where the defendant should spend that time. The state does believe, after speaking with his attorney, that since he is on the medical floor now, and the state, the jail seems to be paying more attention to Mr. Cody in this case, the state would ask for him to serve that time in custody at the jail. However, if the court decides that Mr. Cody is able to go home and spend that time on house arrest or home confinement, we would ask for that to be 24/7 for him to be able to be at the home at all times, and leaving if he has like a doctor's appointment, need to come to court or speak with his attorney. But all in all, Your Honor, because of these 2 newly offenses committed by the defendant while being on probation for a similar charge, we are asking for the balance to be revoked and for that time to be served at the jail.
Okay. Ms. Simpson, beyond these 2 incidents, the December arrest, whenever it was, and the January arrest, were there issues while Mr. Cody was on probation?
In regards to these cases, no. He's had prior revocation on older cases.
Right, but this 21 SC where he's been on, he basically got a little less than 5 years probation. Any hiccups, revocations or anything in a POM hearing before this? Okay. All right. And if I were to, I think I've seen recently in a case where somehow your office is able to manage curfews. I guess they're basically DCS ankle monitors. Okay. All right. Mr. Cody, anything you want to add?
Oh, no, sir.
So you're on the medical floor now, but is that different from being in the medical unit?
Yes.
What's the difference?
In the medical unit, they watch you 24 hours. And in the unit, you're not being watched. You know, you basically need the other inmates to help you if something happens.
Okay. And tell me, when was the last time you went to the hospital?
It was in March.
This was for the long stay where you were there for a couple of weeks?
No, the long stay was in February.
Okay.
And I stayed in the medical unit the whole time. I stayed in the medical unit about 2 months.
And you're not in the medical unit now?
No.
Is that because things have stabilized a little bit?
They basically said because they needed room for other people.
Okay. All right. So what I'm going to do, Mr. Cody, one is that I find, based on your stipulation, that you violated probation, getting arrested those 2 times. And I am going to revoke the balance. I'm open to the notion of house arrest with an ankle monitor and all, but I think it would be most efficient if we could see if we can resolve your other two cases this week as well. So you don't have to ping pong between here and Clayton and back. Because if the state were to indict or accuse those new cases, they could get a grand jury warrant or something, and then you'd be held in Clayton and be brought back here. So since you're not getting out today regardless, because you've got to go to Clayton, and Mr. Jerome has helped me with the math, my thought is, Mr. Jerome, that I hold off on entering the revocation order for a few days to see if we can get those two cases accused. And then we could get them resolved here so that when Mr. Cody leaves here to go to Clayton, he's got those two cases resolved and the revocation order that will probably say revoke everything but house arrest. I reserve the right to change that because you got to resolve the other two cases and see what happens with those. But if that's going to be the end game is house arrest, so that Mr. Cody has access to more comprehensive medical care, but is staying away from the gambling machines and whatever else goes on in his life when he's moving back and forth between home and the convenience store. That's what we'll do.
All right. And that's fine, Your Honor. If we're going to, do you anticipate that it's going to be on Friday? Or are we?
So that's driven by what the DA's office can do. And all I'm saying, I'm not putting more pressure on Ms. Smith. If she gets back to us to say, hey, we can't pull it off in the next week or so, then I'll just enter the revocation order. Ms. Willingham.
If I can just add something, Judge, it really will be if they can reach a resolution. I will get the accusations done if they have a resolution.
Okay.
But I don't want to file an accusation if there is not an actual negotiated resolution, because then obviously that will start our time clock.
Right.
Prepping it for a trial.
Yeah.
And I don't want to do that to Ms. Smith, but I know that Ms. Smith is prepping for some trials next week, so
Great.
I will step in.
Well, I appreciate the teamwork. So let's do this. Mr. Jerome and Ms. Smith, send an email to me and Ms. Nelson if you guys reach a resolution. If it's not going to be a plea, then we shouldn't spend time rushing to get those accused.
No, I believe we do have a plea.
Well, I'm not going to force the issue right now. I need to deal with these warrants. We got a meeting at 4, but I got to call a colleague about these warrants. So what we're going to do is I'll wait to hear from an email from either one of you copying the other, and then the other person can say, yes, I agree, if in fact there's a meeting of the minds. And then we'll go with what I call Plan A, which would be take pleas on those other two cases as well and wrap it all up. If Plan A doesn't work out because the state wants X and Mr. Cody says, I'm not going to do X, then I can always enter the order revoking his probation and sentencing him to house arrest. Once that's on the books, that takes care of the probation warrant, and Mr. Cody can go to Clayton County. And none of these are you get out today because he has the Clayton situation.
All right.
Okay.
All right.
I appreciate you making it here today on the heels of a trial. That surprised everyone, but in a good way.
Yes.
Mr. Cody, any questions?
No, sir.
Okay. All right. Thank you all.
Thank you, George.
I think that's it for this afternoon's calendars. I know we've got our 4 o'clock, but we're going to take a little break before that. Is there anyone else still back there?
Williams.
His lawyer withdrew the bond motion. So you guys can tell him that. Pardon me? Yeah. I'll loop you in, whatever they sort out. Thanks for helping out. So I'll be back out in just a second. Ms. Rivers and Ms. Harvey, thank you for your help today. We are done with those calendars.
Okay, Judge. Have a good day.
Thank you, Judge.
You're welcome.